And salt first.
Yeah, I don't know. You got to help my brother out.
I think you violated your law.
All rise. Monroe Circuit Court's now in session. Honorable Judge David Williams presiding. Please bow with me for a moment of silent prayer.
Thank you. Everybody have a seat. Let's turn off your cell phones. Got me here. Where's the paper on this case? Come on, sir.
With everything else. It was in alphabetical order from the transport.
Okay, I got you. Yes. I'm called to order Cumberland Circuit Court meeting in special session by agreement in Monroe County. Called Commonwealth Kentucky versus Thomas O'Donnell, 22 CR 00103. You are Thomas O'Donnell?
Yes, sir.
Born in 1961. Last four digits, social security number 6773.
Yes, sir.
Okay, what do we have here? You want to move to your left here? What do you have, Mr. Stockton?
Your Honor, about a week ago, maybe 9 days ago, I got a notice that defense counsel would possibly introduce evidence as to guilt and innocence of a mental defect. As regards Mr. O'Donnell, I've since received a expert opinion from them, a report. I filed a motion for a competency evaluation. In their notice of mental health and defect, they alleged that they weren't raising competence at this time, but they were reserving that issue for later.
Mm-hmm.
And also in his report, he's got various different issues and psychotic diagnosis that they may use. I'm asking that he be evaluated at KCPC in-house on all issues, including competency, insanity, and any type of mental defect because of the following. I have identified at least 65 witnesses that may be identified in this trial. About 31 of those are out of state. When we do set a trial, I'm going to have to domesticate all those subpoenas. And I don't want to have another trial date set. We'd already issued about half the subpoenas when I got the mental health defect because we weren't sitting on this case. We were trying to work it and advance it to trial. I don't want another opinion saying that he's incompetent or there's some other mental health issue a year down the road and we've got another trial date set. So I want to get all of it done so we can advance this case to trial.
Okay, now look, if you'll step over here, man. What's your position on an evaluation as far as defect is concerned?
Your Honor, at this time, we are not raising competency or criminal
I
responsibility.
didn't ask you whether you're raising anything. I want you to respond to my question, okay? What is your position as far as a mental defense? You've given an expert witness. An expert witness has evaluated your client.
Yes, Your Honor.
You've given a report.
Yes,
Do
Your
you
Honor.
take issue to the fact that the Commonwealth has the right to have him examined by a mental health expert?
Your Honor, as to criminal responsibility and competency, yes, because we are not raising those issues. So we do object to that.
Well, I didn't ask that. You know, I'm going to get to the competency issue in just a minute, okay? But, you know, you do not take issue with the fact that since you have a mental health expert, that he has a right to have your client examined for some purpose.
Yes,
Is that
Your Honor.
correct?
That's correct, Your Honor.
Okay. Now, so we go on that. Now let's get to the competency sort of situation. It didn't, when I read that motion, Mr. Stockton, I can see why reserving competency for later would raise a red flag for you, which might indicate. I think that was just a belt and suspenders thing myself. Here's the reason I believe that, because at any time in a continuum between now and the trial, they could raise the issue of whether or not he was competent because of some intervening factor. So I don't really think, if they're not raising it at the time, and I have to determine whether we send somebody for that. And I've seen this gentleman several times. Don't know him personally, but I've seen him several times, and I've seen no issue, nothing that would get even close to me deciding that he needs to have somebody appointed to get his competency So that doesn't bother me, but I understand why it would raise a flag for you. I'm not criticizing you for raising a flag. You understand what I'm saying?
I totally understand your view.
Yeah, yeah. So then what we have to do is, we get to limit the purpose of this examination, in an order. We would almost have to pry into your theory of the defense if you want to let him be examined for some purpose and not other purpose. And you know, the Commonwealth is not entitled to have a complete disclosure of your trial or defense strategy. So therefore, I'm not willing to limit the examination, because if you specifically tried to limit the examination, you would have to expose what your strategy was as to which parts of that you're going to use. So I think that I'm going to order for him to be evaluated as far as responsibility. And of course, there's also the use of the mental health expert for mitigation purposes at some juncture. And that criminal responsibility sort of inquiry would be probably necessary for you to defend in the mitigation stage of it. So I would like to create an order to see, I know y'all object to it, but I want you to review the order so that I won't step on this guy's, your defendant's rights anymore, that will say that he will be evaluated for criminal responsibility and for any issue concerning mitigation.
That's fine. I would also like to put out in there any other issues raised in the report so that KCPC can review that.
Well, those, I think that would probably be the only two purposes, and all the things that are raised in the report would be included under those two purposes. Now, the other thing is I would like included in the order that since there has been no request for a competency hearing until the court receives such a motion, he shall not be examined for the purpose of competency. Okay?
That's fine.
Your Honor,
Now, go ahead.
the one other issue that we would like to address is Mr. Stockton's motion did request for an inpatient. We have reached out to the director of KCPC to see if.
Well, I hope you have more influence with him than Mr. Stockton or I've ever had with him.
Your Honor, I will be honest, we haven't received.
You go ahead and finish. I interrupt you and then Mr. Stockton will get to respond to that.
Your Honor, we had reached out to see if it could be done in outpatient versus inpatient. One for expediency and two, so nobody has to be moved and things like that. We have not yet received a response to that. If that is something that could be accomplished, that it be done outpatient,
Well,
that is what we would request.
He's presently at the Adair County Regional Jail. Do they have a facility there that the person
If I
could?
may speak,
Yes.
Yeah.
we've got better access to KCPC, I guess, because we deal with them on a daily basis, it seems like. But we've already inquired with them, and if it's in the court order, they will evaluate him in person. This is not some possession case. They've got an expert witness that's been able to interview him and examine him, and I think the Commonwealth should have the same right to have
Yeah.
him examined in person.
Yeah, I don't really think it's fair to your client.
Oh, Your Honor, I apologize. They can come in person at the facility where he's
They're
at.
not
They,
gonna do that. They're gonna transport him to the facility up there. They're not gonna bring the psychiatric down.
They would Zoom him if they did it.
Yeah.
they can't, they have been doing some of them in person at the jail
Well, I mean,
facility.
it's hard enough to get them to do it in person. I can't think that it would expedite things to order them to come to
That's considered
Adair
outpatient.
County.
Yeah. but
That's considered outpatient.
Yeah.
What they're talking about is considered outpatient.
Yeah,
Yes.
so no, we'll just, right now we have the trial scheduled for when?
October 27th, I believe.
Do you think it's realistic?
No, they told us if they did a Zoom, it would probably be 6 months, and if they did an in-person, 7 to 9 months. So I don't see any difference between 6 months and 7 to 9 months, I say. I want to, and that way we'll have an evaluation and it'll be thorough and we can move on to trial, hopefully.
Well, that would get us into trial in January or February. I really don't see putting this gentleman on trial around Thanksgiving or Christmas. I mean, it's been my experience that jurors do not concentrate very well on cases when they're worried about Christmas vacation or something like that. Now, we were anticipation, we were kind of looking at January and February schedule where,
I mean, if you're saying, if we sent the order right now, and even
Thinking
at a
maybe
minimum
March.
7 months, yeah,
So I'm thinking
And then
sometime early
plus-
summer.
the report and then the hearing.
well, yeah.
late spring, early summer.
Well, yeah, let's go ahead and send the order and see if we can get them to expedite the thing. You know, I guess they've got a lot of other things going on and everything, but
We'll talk to the fellows, actually, they can expedite.
you know, I don't think y'all would consider it ex parte communication if I talk directly to them. I think I'm entitled to talk directly to them.
Your Honor, if you could, we have no problem
Up
with
to this
that.
point, I've not been able to exercise any influence on them about anything at this juncture, you know. But I might see what the deal is. You know, this gentleman has a right to a trial. And I want to get him a trial and that as soon as possible. At the same time, it's a complicated case and I want to be fair to the Commonwealth also.
And this is my issue. Once the report is complete, and we don't know when the report's gonna be complete. We started working on these subpoenas. This was October trial date. We started working on this in June. Because we're gonna have to domesticate some of these out of state.
Yeah.
So I'll need at least probably 90 days to even get my subpoenas served on this case.
Yeah. Okay. Okay, well, there's where we are. If you create an order,
Okay.
And that
And-
motion's for the 31st in July.
what is it?
The trial. Motion to
The
continue the trial as well as a motion to reschedule the evidentiary hearing.
is all on the 31st, Your Honor.
31st,
And just to,
What kind of evidentiary hearing we're gonna have?
regarding the jail staff.
Oh, yeah,
Yes.
well, we'll go ahead and have that. We'll go ahead and schedule that. We'll have that hearing. And then if anything comes up between now and then, we'll know it as far as the schedule or rescheduling the trial.
Just want to verify on the order, it'd be the criminal responsibility, any issues raised in the report, and there's one other thing.
Mitigation.
Mitigation, okay.
and you're,
Any issue that's raised in the report or any other issue concerning a criminal responsibility or mitigation.
and Your Honor, it was your order that once the order is proposed, that it can be looked at by defense counsel and if
Go
there's
ahead
any.
and send it to you.
Yes, okay.
And if there's something you can agree on to change, we'll do that. If not,
We're the past the point of agreeing on anything.
well, hope springs eternal.
Well,
Just give me an opportunity to give it to them.
I will give it to them.
Give it to them, and you don't have to talk to them about it. You know, if they can send you something in writing. And I would hope that we would reestablish a little better communication between the defense and the prosecution at some juncture. I understand that this team comes in, but I'm not going to be very tolerant of people that just come in to try to, as they say in Monroe County, gom things up. If you have legitimate motions, that sort of thing, I'm more than willing to hear them. But this system does not work unless there is professional courtesies extended by both sides. Okay, both sides. And so let's try to reestablish some of that again. So you can talk to your colleagues about that.
Understand, Your Honor.
I'm talking to both sides about it. Okay, thank you very much. Jacob Bowles.
I'll get that back over.
Jacob Bowles.
Criminal responsibility mitigation and what was the other one?
Commonwealth versus Jacob Bowles, 22 CR 002. Are you Jacob Bowles? Mr. Bowles, come around. Are you Jacob Bowles?
Yes, Your Honor.
Were you born in 2002?
Yes.
The last four digits of your social security number 1163?
Yes, sir.
You're here for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yeah.
Is it substantially correct?
Yes, Your Honor.
Counselor, is there any reason this gentleman should not be sentenced today?
Your Honor, no, but I would like to make a motion for probation.
Okay, please proceed.
Your Honor, I would ask the court to probate Mr. Bowles. I believe that he is a good candidate for probation. This is a pretrial diversion revocation, so this came out of pretrial diversion revocation, so this would be his first felony conviction. He has minimal criminal history. He would be living in Glasgow, so he would be able to be monitored by the local probation office. It is my understanding that he previously has work history within factories around the area, so he'd be able to be
Where
employed.
did you work, young man?
Agavona.
And he does have contact information that he has made sure is correct for probation to be able to monitor him.
It was a Commonwealth, I have to say.
Well, Your Honor, he was placed on probation in June of 2022, or I'm sorry, May of 2022,
Pretrial diversion.
pretrial diversion. And he basically absconded in June of 2022, and he's been absconded for 3 years.
No, objection, he was not. He was not. Absconding was not one of the allegations there. He was compliant up until the violation of the new misdemeanor.
May have him confused with somebody else. He was convicted of domestic violence assault fourth on May 29th, 2025 in Barron County. So I don't mind looking at it as shock, but I don't think it should be probated.
Well, I'm gonna go, he's been, the pretrial diversion has been set aside. I'm gonna go ahead and impose the sentence, but I will encourage you to file a motion for shock probation as soon as he's eligible. And that will allow us for both you and the Commonwealth to give a little bit, some testimony. I'd like to hear some testimony on it. And the fact that he does have a work history interests me very much. We have so very few, I'd like to go into detail about his work history and that sort of thing. And I think that we'd be glad to take a look at it. He doesn't seem like to be have that much of a criminal history at this juncture. So you just make sure you conduct yourself appropriately in corrections and work with your attorney to get this motion filed, and we'll consider it when it comes up that. Okay? Okay. Thank you. Jenna Gregory. Jenna Gregory. Gino? Mistype on that. Are you Gino Gregory?
Sir,
What's your year of birth?
January 12th, 1996.
Last four digits of your social security number, 8808.
Yes.
You're here in 25 CR 0027 for sentencing. You have that pre-sentence investigation report. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole?
Yes, sir.
Is it substantially correct?
Yes, sir.
Counselor, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On plea of guilty possession of controlled substance, first degree, first offense, methamphetamine, the defendant shall receive a sentence of 2 years, probated for 4 years, and shall enter the Monroe Specialty Court. Has he been
He's been accepted, Your Honor.
been accepted? Okay. What are the court costs in this case?
165.
165. I will delay any payment on that until you're out for 30 days. You can pay $30, 30 days after you get into the drug court, $30 a month if that's paid. Okay? Has he been voted in yet to the drug court? Okay. And when can you do his orientation?
That I don't know. We'll have to find out from the.
Okay, well, I'll sign an order releasing it on the day you can do your orientation. Do you live here in Monroe County, Mr. Gregory? Well, I'll try to let you out enough so you can have somebody pick you up, bring you over here. Unless you clean up and stuff before you go to the drug court. I hope you make it through the drug court, man.
Already.
Okay. William Miller, it says there's an active warrant out for William Miller. Do we have?
He's been transported, Judge. He has an active indictment.
Here he is.
He has an active indictment warrant that Roller wouldn't serve as far as we were made aware. So
Your Honor, it had been started.
the Commonwealth had him transported for the purpose of service and.
Okay, and has he been processed? Okay. Okay, I guess if you give me the file here. I'm gonna appoint public advocacy to represent Mr. Miller. I would say, Mr. Miller, you probably don't have, since you're incarcerated, you don't have the financial resources to hire.
No, I got him.
Okay. Commonwealth versus William Miller, 25 CR 0025. You are William Miller.
Yes.
You were born in 1980.
Yes.
Last four digits of your social security number, 2359.
Yes.
You have the right to remain silent. You're represented by counsel. If anytime you have any questions, you can step away and ask your attorney. The grand jury of Monroe County has returned an indictment charging you possession of controlled substance, first degree methamphetamine, giving a false identification to a police officer, failure to signal, and operating on revoked or suspended. You understand what those charges are?
Yes.
Okay. Counselor, do you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions?
Yes, Your Honor.
I'm signing a reciprocal discovery order right now, Mr. Miller, that requires the Commonwealth to give your attorney information to help you prepare for your defense. When is the negotiation day, Mr. Stockton?
It would be August the 8th at 9 o'clock.
Okay. I'm going to schedule you for August the 8th at 9 o'clock to be here for a negotiation day. And the next court date would be on August the 14th.
Thank you, Your Honor.
Give that to the officer there. Okay, Commonwealth versus Jody Murphy.
Yes.
Commonwealth versus Jody Murphy, 24 CR 0060. Are you Jody Murphy?
Sir.
Good morning. You born in 1999?
Yes, sir.
Last four digits, social security number 6590.
Yes,
You're here today for sentencing. Have you had an opportunity to look at the pre-sentence investigation report done by probation and parole? Is it substantially correct?
Yes, sir.
Okay. Counselor, is there any reason why this person should not be sentenced today?
No, Your Honor, but I would like to make an argument for probation.
Please proceed.
I would like to take testimony, Your Honor.
Okay.
And Your Honor, I would like to call Ms. Bethany Steenberger and the alternative sentence worker with the public
Okay,
defender's
take it.
office.
Okay, you need to get the witness seat there. Okay, raise your right hand. You swear the testimony you're about to give is the truth, the whole truth. Have a seat, state who you are and what your position is.
My name is Bethany Steenberg and I work for the Glasgow Public Defender's Office as an alternative sentencing worker.
You may proceed.
Ms. Steenbergen, have you met with Ms. Murphy and assessed her situation?
I did.
Okay, and can you explain to the court, what it is that is going on with us?
So Miss Murphy is, I want to say around 22 weeks pregnant.
2 weeks and 2 days.
It's what?
She's 22 weeks pregnant.
Yeah.
Based off of her records that we've gotten from Dr. Craddock's office, she is a high-risk pregnancy. Because of,
You have those records with you?
I do not, they are with our investigator, I'm sorry.
Your Honor, I did submit to the court, last time a letter from Dr. Craddock's office. I believe if that is not in the court, I can provide that to, in the file. I can provide that. And actually, I do have a copy of what we obtained. I can go ahead and submit to the court.
Give it to the Commonwealth to look
I
at.
believe
I think
that
I've seen,
it's,
it's the same one she
Yeah.
furnished last month.
yeah.
That's what I've seen.
Okay. That's his exhibit. Just give it over to, that's exhibit 1 to the witness's testimony. Okay, go ahead.
Ms. Steenbergen, have you, discussed with Ms. Murphy alternative to incarceration?
Yes.
And can you explain to the court, what that is?
So I have obtained a bed letter for the Chrysalis House, which is a rehab facility for pregnant women in the state of Kentucky.
Can you explain, what treatment looks like at the Chrysalis House?
So their program is in Lexington. It's right across the street from a delivery center. They are a 4 to 6 month program that allows women to return to the treatment program even after having the baby.
And, is this a treatment facility for substance abuse?
Correct.
And would she be receiving, counseling and other type of treatment for substance abuse while she is there and while she is pregnant?
Correct. Substance abuse, job readiness, parenting classes, and aftercare services.
And why do you believe that this is an appropriate alternative to incarceration for Ms. Murphy?
I don't think any baby deserves to be born in jail, but not just that, but the cost alone is substantial to our local agencies being a pregnant woman incarcerated. And I think that she deserves an opportunity, if you're having trouble with substance abuse, to get that help.
And who pays for her treatment at this facility?
Her insurance company would.
Okay, so it would not cost any.
Correct.
Okay. I have no further questions.
You say her insurance company, does she have private insurance?
No,
So it would be the government paying for it, whether the state of Kentucky pays for it or the federal government pays for it, the government's gonna be paying for her care.
Medicaid, be Medicaid.
wouldn't be our local taxes.
K-CHIP, probably.
That's probably right. I have no other
Well,
question.
you look at, I was looking at this, report, it says nature of offense down at the bottom. I guess it says on 7/2/2020, the defendant appeared before the Clinton Circuit Court along with counsel. Is that
No,
It's a misdemeanor.
no, the motion to revoke was heard in.
was heard in Clinton County?
I think
Your Honor, we did that.
So
for
actually it was heard in
Yeah,
Clinton
special
County,
hearing.
but Monroe Circuit Court. So it wasn't in front of Clinton Circuit Court, it's in front of Monroe Circuit Court meeting in Clinton County.
That's
Okay.
Yes. We had requested to be heard in Clinton County on this case
Yeah, okay.
for timing purposes.
Yeah.
I have no further questions for Ms. Steenbergen.
Do you have any questions for, you may send down. Do you have any other witnesses?
No, Your Honor, but I would like to make the argument.
Let Mr. Stockton see it. Do you have any witnesses, Mr. Stockton?
No, we put on the proof as to the revocation and when we were.
You
sitting in
stand
Clinton
on
County.
that?
I'm standing on that.
Okay, go ahead. You can make your argument.
Your Honor, I would ask for the court to probate Ms. Murphy. As the court has heard, she has significant reason to be probated and specifically to be sent to the treatment program. This would allow her to obtain help for substance abuse and also enable her to be able to receive the medical care that she needs.
Let me, I read, I'm aware of the letter and what, and your arguments are good, it's a good argument. But what gives me any level of confidence that if she's not revoked, that she won't get out and take drugs and hurt this baby?
Your Honor, that is what the treatment program would be for. I do think that one thing that was going on during the entirety of her pretrial diversion was instability, and this would allow her to become stable, which would also help her remain sober.
How far along is she?
22 weeks. So she's due in November, October.
So about the
November.
time she's eligible for shock probation would be about the time she's gonna have the baby, right? Is that right, Mr. Stockton?
She'd be eligible for shock in 30 days. So that's another 4 weeks. She'd only be about 27, 28 weeks.
Yeah.
She's still like a trimester.
Your Honor, I do have a concern with regard to Ms. Murphy and any continued medical visits that she would necessitate while in the Barron County Jail. Because she has been incarcerated for so long, she no longer has Medicaid, which means that it would be up to either the jail or DOC to pay for her
Be
medical.
up to Monroe. She's a state prisoner, so it'd be wouldn't be up to the jail. It'd be up to Department of Corrections.
Not, but if she were in treatment, she would be able to get Medicaid back, and that would pay for it rather than DOC doing so.
Well, I don't see the difference between DOC and Medicaid paying for anything. It's out of one pocket. Both of them are, the only difference would be a portion of the Medicaid payment would be paid for by the federal government. But I appreciate your concern for the financial situation that the Commonwealth is in, but at this juncture, I just don't feel comfortable not incarcerating her. So we'll take a look. If you get additional proof about her condition or want to have a hearing at some juncture on the motion for shock, I'll consider that, okay? Thank you very much.
Uh,
Callie Strong. Callie Strong. Commonwealth versus Callie Strong, 22 CR 0061. Are you Callie Strong?
Yes.
Good morning. What were you born in 1969?
Yes, sir.
Last four digits of your social security number 2609.
No,
What is it? What are the last four digits?
7609.
76. Okay, we have a typo. 7609. Okay, you're here on 22 CR 0061, a pretrial diversion revocation. Now, Mr. Johnny Bell previously represented you. Is that correct?
Yes.
But now you're represented by public advocacy.
That's correct, Your Honor.
What does the Commonwealth have to say in this case as a pretrial diversion
If
revocation?
they want a hearing, I've got Mr. Graves' opinion. When he gets up here, we can have a hearing.
Your Honor, we're not asking for a hearing at this time. I've spoken with Mr. Strong. He wishes to stipulate to the violations and
Okay.
stand for vote today.
And what does the Commonwealth want to do? Tell me what the violation was, and since they've
Well,
stipulated.
he went into the specialty court because he tested positive for meth and marijuana. And I'm limited on my knowledge on the drug court violations because it says in the referral that he absconded from the program on 2/28/25, and he was in violation of the participation agreement that he signed on 12/17/24. That's one reason I subpoenaed Mr. Graves. Now, Deputy Richardson did tell me that when the warrant was in there, that Mr. Strong came and turned himself in, and he was clean at that time. Is that right?
Yeah, because he asked me to drug test him because he said he was one.
But that's all I know about the case. So
Where's Mr. Graves?
I guess he's still in drug court. I've got a subpoena. He's supposed to be here as soon as he's available.
Hmm?
I said this is a pre-trial version.
So we should set it for sentence.
Stay for vote, you're have to get sentenced.
Yes. He said,
He's here. Mr. Graves is here. He can.
This is a pretrial diversion revocation.
Yes.
Mr. Graves, you want to come around here? Let's talk about Mr. Strong just for a second. You raise your right hand. Swear the testimony about to give us the truth, whole truth, nothing but the truth. He is stipulated as to violation. Could you catch me up on exactly what happened to Mr. Strong? Do you remember? Yeah, he just didn't show up.
didn't show up. Called him, didn't get any answer. And so the judge issued a warrant.
Okay. Thank you very much. You're excused. I'm going to go ahead and revoke his pretrial diversion. Ask a pre-sentence investigation report be done by probation and parole. We'll schedule sentencing for August the 14th, and any arguments that you might make, you can make then as far as probation is concerned, okay? Damian Tackett. Damian Tackett. Combo versus Damian Tackett, 25 CR 0019. Are you Damian Tackett?
Yes.
Good morning. Were you born in 1984?
Yes.
Last four digits, social security number 4520.
Yes.
We're on a pretrial conference. What do we have?
We have a felony plea, Your Honor.
Okay. Ms. Tackett, I understand a motion has been tendered that says you wish to enter a guilty plea. Is that correct?
Yes.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
Are you the same person named in indictment number 25 CR 0019?
Yes, sir.
Is your judgment impaired today in any way?
No, sir.
Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? You believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights.
Yes, sir.
I'm going to go over them, and at the end, I'm going to ask you if you understand. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in your favor, right to appeal this matter to a higher court if you lose, Right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of the charge against you. Understand it, but in a guilty plea today, you give up all those rights. You understand that? Yeah, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided below. I don't have to accept the recommendation. Prior to accepting the recommendation, I will review the pre-sentence investigation report done by probation and parole. In the event that after reviewing it, I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence on you, you have a right to withdraw your plea and proceed to trial. You understand that?
Yes, sir.
Mr. Stockton, are you going to present it? Will you step to the left, or step to your left over there? Listen very closely, sir, okay?
Upon a plea of guilty to criminal mischief first degree, the defendant shall receive a sentence of 5 years, probated for 5 years, supervised. He'll pay $1,592.47 restitution at the monthly rate of $100 per month, plus the clerk's fee, beginning 30 days after he has been released from incarceration. Each subsequent payment will be due each day thereafter, 30 days on the same month. He shall receive credit for time served, but be released upon final sentencing. He agrees all evidence will be destroyed and will obtain and maintain gainful employment.
Move back over here. Is that what you agreed to, sir?
Yes, sir.
Are you pleading because you did commit the acts charged in the indictment as amended?
Yes,
Did you plead guilty of your own free will?
yes, sir.
As I said, you had plenty of time to review this and you're satisfied with your attorney's representation.
Yes, sir.
Knowing your constitutional rights have extended to you, is it still your desire to proceed and allow the court to fix your punishment as permitted by law? Is that right? Okay. Is that your signature on the document?
Yes, sir.
Do you realize after entering this plea, any future convictions could be enhanced under the persistent felony offender law? Do you understand that?
Yes, sir.
I accept the agreement, order pre-sentence investigation report, schedule sentencing on August the 14th. Okay, thank you very much. Michael Vibert. Michael Vibert. Are you Michael Vibert?
Yes, sir.
Good morning.
Good morning.
We're on 25 CR 005 and 25 CR 0033. Mr. Vibert, were you born in 1977?
Yes, sir.
Last four digits, social security number 1680.
Yes, sir.
Okay, we're here today on, says to enter a plea and on an arraignment on an information charge. Is that correct, Counselor?
Yes, Your Honor.
Okay, by information, just hold right there. By information, you're charged with, 4 counts. On about the 30th, you're charged with fleeing and evading.
On the information, Jesse.
Yes, Your Honor. Be fleeing, evading seconds, what he's pleading to. He'd be fleeing and
You're
evading.
charged with fleeing, evading, second, reckless driving, operating motor vehicle with expired license, and persistent felony offender first degree. That's what you've been arraigned for. You acknowledge the receipt of the information,
Yes.
waive formal reading and arraignment. And now he's going to enter a guilty plea to some of those things. Is that correct?
Yes, Your Honor.
Okay. A motion's been tendered, says you wish to enter a plea today. Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given? You're the same person that we just identified in 25 CR 005 and 25 CR 0033. Is that correct?
Yes, sir.
Is your judgment impaired today in any way?
No, no, sir.
Have you discussed this matter with your attorney? Are you satisfied with her advice?
Yes, sir.
Have you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case.
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. You have a right to speedy trial by jury, right to be represented by counsel at your jury trial. Right to confront and cross-examine all witnesses called to testify against you, right to produce evidence, right to call witnesses in favor, right to appeal this matter to higher court if you lose, and right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charge against you. You understand that by entering this guilty plea today, you give up all those rights. You understand that?
Yes, sir.
I may consider the Commonwealth's recommendation, but I may plainly range of sentence allowed by law. I don't have to accept it prior to accepting a recommendation. I would usually ask for a pre-sentence investigation report. However, because you're a state prisoner, that might be waived. Is that correct, Mr. Stockton?
Yes, sir.
Okay. In the event that I do not accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. If you'll step to your left there a little bit, sir, Mr. Stockton, come around and tell us what the Commonwealth's recommendation is.
Your Honor, in indictment 25 CR 5, Mr. Vilbert will plead guilty to wanton endangerment, first degree, 3 counts, and persistent felony offender, second degree, 3 counts, and receive a total of 10 years on each count to run concurrently for a total of 10 years. Also in 25 CR 5, he will plead guilty to the charge of fleeing or evading police, first degree, a Class C felony, and receive a sentence of 10 years. The two 10-year sentences shall run concurrently for a total of 10 years in that indictment. In the information indictment 25 CR 33, he will plead guilty to fleeing and evading police, second degree, receive a sentence of 5 years. The 10-year sentence in 25 CR 5 and 25 CR 33 shall run concurrently according to the Commonwealth's recommendation for a total of 10 years. The Commonwealth opposes probation and shock probation. He shall receive credit for time served.
Is that what you agreed to, sir?
Yes, sir.
Are you pleading guilty because you did commit those acts charged in the indictment as amended?
Yes, sir.
Of your own free will, knowing your constitutional rights to sue your desire to proceed out of the court to fix your punishment. You understand that any future convictions after entering this plea could be enhanced under a persistent felony offender. Is that your signature on the document?
Yes, sir.
I accept the agreement, waive pre-sentence investigation report, and will impose sentence. Can I get some help on this corrections department form where y'all fill in the point where it says what he pled guilty to? No, give it to the Commonwealth Attorney's office. Would y'all help us and fill that in there on what he pled guilty to, because
You are done. They're gonna get all your papers.
it will not be necessary for him to come back for sentencing, because I'm waiving the pre-sentence investigation report and putting the sentence on there today, okay? Okay, good luck to you, Mr. River.
Thank you, sir.
Oh, see,
I signed it.
You did something.
Yeah, I filled it in, okay. Brittany Williams.
Your Honor, Lee Davis for Miss Williams.
Commonwealth versus Brittany Williams, 25 CR 0021. You are Brittany Williams, born in
Yes, sir.
1991, last 4 digits, social security number 2941. We're here for pretrial conference. Is there a plea in this case?
There is, Your Honor.
Is it a felony plea or pretrial diversion?
Pretrial diversion.
Okay.
The big cat.
Ms. Williams, a motion has been tendered, says that you wish to enter plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily entered? You're the same person we just identified in 25 CR 0021. Is that correct?
Yes, sir.
Is your judgment impaired today in any way?
No.
Is judgment impaired? You know what's going on here?
Oh, yes.
Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes,
Have
sir.
you reviewed the evidence the Commonwealth has against you? Believe you're fully informed about your case?
Yes, sir.
You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I can accept the plea, I need to know that you fully understand those rights. I'm going to go down through the rights and ask you at the end if you understand. If any time during this time you need a chance to talk to your attorney, please inform me, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury. The right to be represented by counsel at your jury trial. The right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. The right to call witnesses in your favor. Right to appeal this matter to higher court if you lose. And right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty charged against you. Understand that by entering a guilty plea today, you give up those rights. Is that correct?
Sure.
And I may consider Commonwealth's recommendation, but in this particular situation, it's a pretrial diversion, so I'll make my decision today. So I'm going to ask a couple of qualifying questions. Have you previously been diverted in the last 5 years?
No, sir.
Have you felonies in the last 10 years?
No, sir.
Are you currently on probation?
No, sir.
Have you, you understand if you fully complete the diversion agreement, the charges will be dismissed, pretrial diverted, and you can have your record expunged. You understand that?
Yes, sir.
If you don't successfully complete, however, you can be brought back in front of me, and if I revoke your pretrial diversion, I'd have a pre-sentence investigation report, you'd be a convicted felon that could be used against you in the future. Do you understand that?
Yes, sir.
Mr. Stockton, will you come around with the Commonwealth's recommendation?
Yes, Ms. Williams will plead guilty to possession of a controlled substance, first degree methamphetamine, receive a sentence of 3 years, serve 60 days in jail with a balance pretrial diverted for 5 years supervised. She'll receive credit from time served. I believe she has in excess of 80, almost 90 days in jail. She'll be referred to the SSC, follow all recommendations. All evidence in this case will be destroyed. She would obtain, maintain gainful employment.
Is that what you agreed to, ma'am?
Yes, sir.
Are you pleading guilty because you didn't commit the act charged in the indictment?
Yes, sir.
Do you plead guilty of your own free will?
Yes, sir.
Okay, knowing the constitutional rights that explain to us your desire to proceed in and putting allow the court to fix your punishment. Is that your signature on there?
Yes, sir.
Okay, I'll accept the agreement and sign the diversion order. Is that 60 days to she's already killed it?
She's served 84 days as of today.
Yeah, today, I've been in there
Are you
84
going out
days
today or tomorrow?
today, please.
Well, that shows that you do know what's going on.
Yes,
sir.
Okay, well, we'll go ahead and sign the papers. I'm sure you'll have to be transported back over, so you'll need to get somebody to pick you up over there, okay?
Okay,
Thank you, Your Honor.
You need to meet with the probation and parole officer just for a second and give them certain information.
Yes, sir. Thank you.
Yeah,
Thank
no
you.
problem. Dakota Williams. Commonwealth versus Dakota Williams. 22 CR 0018, 22 CR 0019, 22 CR 0021. Are you Dakota Williams?
Yeah. Yeah.
Okay, were you born in 2003?
Yeah.
Last 4 digits, social security number 4744. We're on shock probation. 4741?
Yeah.
Okay, we'll correct that. 4741. We're here today on probation revocation. Will you step to the left? You'll call a witness.
Your Honor, Mr. Williams has, this is our motion to revoke shock probation. He has a 15-year sentence on 3 different theft cases.
Okay.
And I call Mr. Collins.
Mr. Collins, you raise your right hand. You swear the testimony you're about to give us the truth, whole truth, nothing but the truth.
I do.
Please proceed.
Mr. Collins, we've not had a hearing on this. I want to go back to August the 12th of 2024 to tell the court what happened.
So on 8/12 of 24, while conducting a home visit, I found the following items on a headboard on Mr. Williams's bed.
I have to object. The motion that we have received this month for Mr. Williams only includes a new felony charge that he had acquired, I believe, last month. We do not have anything in that motion regarding this.
Well, we had it emailed to you on June 24th, 2025.
Yes, Your Honor, there have been revocation proceedings pending on Mr. Williams since then that have been resolved with various sections by agreement with Mr. Stockton. These issues would have already been taken care of.
I don't know that I agree with that. We had it, last thing I'm showing, September of 2024. He was supposed to go to long-term treatment, and I was getting to that.
Your Honor, we had a revocation pending proceeding on Mr. Williams just within the last couple of months, and it was resolved by sending him, I believe, to a sober living facility.
Okay. Yeah.
Does he have another violation?
Yes, sir.
I
will go ahead.
wait. I think I can collectively look at his entire activity, even though we decided at that time not to take an action on it, because I think I need to look at his actions cumulatively. So I'll overrule your objection. You may proceed.
So what happened on August the 12th, 2024, Mr. Collins?
Your Honor, I'm sorry, I do have to object again. Yes,
Well,
Your
okay, you've recorded it. You recorded it.
Agreements in lieu of revocation.
Okay, I understand, but I've got a right not to look at this in a vacuum. I could look at his pre-sentence investigation report. I can look at anything I want to that's relevant for me to make a cumulative decision on whether or not what he's done most recently tips the boat. So I note your objection. I overrule it. Proceed.
On 8/12/24, I conducted a home visit. While doing that home visit, I found 1 wooden box, 4 syringes, 10 orange syringe caps, a clear baggie, and 1 orange rubber band. On that day.
Did he make any admissions to drug use, or did you take any action because you found those items?
Yes, once we found those items, he did admit that he was using, and we decided to send him to treatment in Bowling Green.
Okay, was that Kentucky Southern Living or so?
So it was correct.
Okay, and how did he do in that treatment facility?
While he was up there, the officer that was supervising that case sent a violation report for failure to cooperate with probation and parole office. And it states subject reported on 2/13 of 25. He was advised he was going to be drug tested. Drug test was attempted, but he could not provide a sample. He was advised to wait in the lobby until he could produce and left before he could be tested. Then it was fair to abide by the rules of the halfway house. He was dismissed from Soki Sober Living over the weekend of 2/8 to 2/9 for failing a drug test. And then the next violation there was absconding. It said subject left the probation and parole office on 2/13/25 after being advised he needed to provide a sample for drug testing. And then that officer attempted to call him several times. The phone rang once, went to voicemail. Officer stated he texted the subject with no response. He called subject's emergency contact and the phone was disconnected.
Okay. When was the next time that anybody through the state of probation and parole was able to supervise Mr. Williams? Or has he been supervised since February this year?
He did go back in and we allowed him to go back to sober living in Bowling Green.
Okay.
To my knowledge, he was working, I believe in Logan County. I believe that was correct. And during that time, it looks like he picked up a couple traffic tickets for operating. One was 25T 451, operating on a suspended or revoked license. And then on June 10th, it looks like he had another one on 25T 1123 out of Logan County. Was again operating on a suspended, revoked operator license and no expired registration plates. And then he did receive the conviction on the, it looks like on the 24T 719, operating on a suspended, revoked operator license. During that time, he, I can't recall if he completed the sober living home. He may have done that. He did come back to Monroe County, and then once he was here in Monroe County, that's when he picked up the new felony charges.
What's the new felony charge?
On 6/19/25, Mr. Williams was charged in Monroe County case number 25F44 for possession of burglary tools and burglary third degree.
And during this time, have you been drug tested?
I wasn't supervising him. He had just come back from Bowling Green.
Okay.
Is that case still pending?
It's still pending. It's not went to the registry.
Okay, you want to inquire?
Mr. Collins, I want to go back to the violations that you mentioned, I believe in February of this year, where he had allegedly absconded and failed to abide with the conditions at the sober living home. Was he granted a sanction in lieu of revocation for those violations?
To the best of my knowledge, we sent him back up there to the sober living home, or I believe that's what we've done.
And you're not aware of any other violations at the sober living home?
Not to my knowledge, no.
To the best of your knowledge, he had completed that program.
Yes.
Regarding the new felony charge that Mr. Williams picked up last month, do you have any information beyond the fact that he was charged?
No.
Are you aware of who the victim is?
No.
You're aware of anything that it was that took place to
No.
lead to him being charged?
I'm not.
Okay, I have no further questions.
No regret.
You have any witnesses you'd like?
No witnesses at this time, Ron.
Okay, I don't have enough information in front of me now to revoke him on the new charges, but I do have enough to hold him. I don't know whether the grand jury is going to take that up today or
It'll be next month, the third.
next month. So maybe you could proceed by information so we could get the thing rolling a little bit to pick him up a month.
That's something I can discuss with Mr. Williams.
That's right.
Yes.
I know you have to discuss it with
Yes,
him.
Your
You
Honor.
can't do it. So, but, okay, thank you very much. We continue to be held. Okay, I'm going to switch over to see if Christian County was scheduled at 10. Is Christian County on the line? Steve Brown,
No, we only have Jesus Padilla on.
Green River Correctional Complex.
Yes, sir.
Okay, Commonwealth versus Jesus Padilla. 24 CR 0076. Are you Mr. Padilla?
Yes, sir.
You were born in 2002.
Yes, sir.
You have a social security number?
No.
Okay, we're here on a pretrial conference. What does the Commonwealth have to say?
Your Honor, I've communicated with Ms. McCauley, and I believe she has all the discovery now. I don't know if she wants a trial date or one more pretrial.
Judge, I had
Securus meeting with Mr. Padilla that he apparently didn't get informed about. We've rescheduled it to Monday, so I'd ask for one more pretrial until I've had a chance to discuss
Let's have
the.
a negotiation day, scheduled for the 8th of August, and the next court appearance will be on August the 14th, and you enter plea there, I have a trial date, okay?
Mr. Padilla, I've got another meeting set with you, on Monday at 11:30, okay? Check your tablet.
Okay, I got you.
Okay, thank y'all very much. Green River, you may be excused. Could could y'all call Christian County to see what the deal is on that Department of Corrections, Christian County Detention Center on Stephen Brown? And then we have the Marion County. Marion County is supposed to be on there. I don't see Marion County. So that's a motion for shock probation. We can pass over that. DPA, do y'all represent, did y'all file this motion for Christopher Sutton for shock probation?
Yes, Your Honor, we did.
Did you do a transportation order on it?
Your Honor, we did not do
Oh,
a
I did an order of
transportation.
appearance on Zoom and sent it to Christian
I'm not talking about Marion County
and
and
Marion
Marion
County.
County. So we could call Marion County also, okay? Could somebody get a hold of both of them and we'll take them up? Marion County detention is not scheduled till 10:30, so we'll go back to the out of custody docket. Commonwealth versus Nora Adams. Nora Adams. How are you doing? Commonwealth versus Nora Adams, 25 CR 0034. Are you Nora Adams? Let her behind the microphone, counselor, if you would. Were you born in 1978?
Yes, sir.
The last four digits, social security number 2729. You're here today on information indictment. The Commonwealth attorney charges that on the 30th day of June 2025 in Monroe County, the above named defendant did commit the offense of possession of controlled substance, first degree, first offense against the peace and dignity. You acknowledge the identity of your client, receive the information indictment, waive formal reading and arraignment, enter plea of not guilty, waiving all formal arraignment.
Yes, Your Honor.
Okay. You're here to enter a plea today, is that correct?
Yes, sir.
Okay, is it a pretrial diversion or a felony? Okay. Ms. Nora Adams, the motion's been tendered, says you wish to enter a plea today. Are you currently under the influence of drugs or alcohol? Is this plea freely and voluntarily entered?
Yes.
Are you the same person that is named in 25 CR 0034?
Yes.
Have you discussed this matter with your attorney and are you satisfied with her advice?
Yes.
Are you impaired today in any way? Okay. Have you viewed the evidence Commonwealth has against you? Believe you're fully informed about your case? You feel like you're fully informed about your case? You understand that you do not have to enter a guilty plea today. You have certain rights under the Kentucky and United States Constitution. Before I accept the plea, I need to know that you understand those rights. You have a right not to testify against yourself. No one can make you say anything. Right to speed trial by jury, right to be represented by counsel at your jury trial, right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence, right to call witnesses in your favor, right to appeal this matter, higher court if you lose. You have a right to acquire the Commonwealth prove on a reasonable doubt that you're guilty of charge. You understand? By entering guilty plea today, you give up all those rights. You understand that? Now, I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided by law. I don't have to accept it. In the event that I do not accept the recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea and proceed to trial. You understand that? I'm going to ask you some qualifying questions. Have you been previously diverted in the last 5 years?
No.
Have any felonies in the past 10 years?
No.
Are you currently on probation? Are you on probation now?
Yes, sir.
No, you're not.
It's a misdemeanor probation, Your Honor, not a felony.
Are you on felony probation? No. You understand that if you fully complete the diversion program, the charges will be dismissed, pretrial diversion, you have your record expunged. You understand that? You understand if you do not fully complete the diversion program, you'll be brought back before this court. If I revoke the pretrial diversion, I'll have a pre-sentencing investigation for it done and sentence you and you'll be a convicted felon that can be used against you in subsequent felonies. You understand that? Mr. Stockton, will you come around and present the Commonwealth's recommendation?
Upon a plea of guilty to possession of controlled substance, first degree, first offense, she would receive a sentence of 2 years, pretrial to verdict for 4 years. She would enter and complete the Monroe County Specialty Court. She'd receive credit for time served, obtain and maintain gainful employment, and all evidence in this case would be destroyed.
Is that what you agreed to?
Yes, sir.
Are you entering this plea because you did commit the acts charged in the indictment as amended? Okay, are you pleading so of your own free will? Knowing your constitutional rights, explain to us that still your desire to give up those rights and enter a plea of guilty to the charges and allow the court to fix your punishment and within the range permitted by law. Is that your signature on the document?
Yes, sir.
Now accept the agreement, sign the diversion order. Was there any time for her to serve?
I don't know if she's even been in jail or not.
I think she might have done a day or two, Your
Yeah,
Honor.
I want to make sure she,
I'm certain.
make sure she gets credit for it. It's the reason I'm asking. You need to be interviewed by the probation parole officer. Has she been voted into drug court yet?
No, she just, there's just been should be a form for you to sign, have her assessed.
Well, it's kind of unusual for us to have somebody enter one of these pleas that's not incarcerated and then wait a while. I mean, it's not, that's what happens when we have these rocket docket things. So what do you want to do about that?
We'll just let probation parole keep the tabs on her until she's entered into the drug courts. And if she doesn't go into drug court, I'll come back and ask that she be supervised for probation parole.
I did double check her phone number on the referral form, Your Honor, so they should be able to get a hold of her.
Okay, well, he's right here. Get her information, okay? Make sure the referral gets set up. She'll need to be given the information where she can get a hold of the drug court to be interviewed and that sort of
I
thing.
won't have a report back at one today, Your Honor. Larry will be there.
Okay, that'd be fine. Kelly Bratcher. Commonwealth versus Kelly Bratcher, 21 CR 00102 for arraignment.
Morning, Judge.
Good morning, Mr. Bell. Are you Kelly Bratcher? Are you Kelly? Let her have to be the, you don't have to be the star.
Part of me.
Later, your part will be later in the play. Are you Kelly Bratcher?
Yes, Your Honor.
Good morning.
Morning.
You're here today on 21 CR 00102. Were you born in 1981?
Yes, Your Honor.
Last four digits, social security number 9331. You have the right to remain silent. The grand jury of Monroe County has charged you with possession of drug paraphernalia, trafficking in controlled substance, possession of controlled substance, and possession of marijuana. Do you understand those charges?
Yes, Your Honor.
Mr. Bell, do you acknowledge the identity of client received indictment, waive formal reading and arraignment, enter plea of not guilty on the charges?
Yes, Judge.
I'm signing a reciprocal discovery order, ma'am. It requires the Commonwealth to provide you with the information they have to help you prepare for your case. You'll be here on August the 8th for a negotiation and August the 14th for your next court appearance. Both those are conditions of your bond.
Judge, I got a trial or mediation set on the 14th. If that was to get, go forward, I'd have to continue that, but if it doesn't, I'll be here.
Well, if it gets closer and you can't be here, you can just file a motion or reach an agreement. Either
Yes,
one. But she's under the obligation to be here until you show her an order otherwise.
Yes, sir, Judge.
Christopher DeWeese says active warrant.
We'll put him in CIC. Oh, well, we don't need to.
Okay, you need to take Mr. DeWeese into custody and process him, okay? Mr. DeWeese, you come with them, they're gonna serve the warrant on you and process you, okay? Brian Elliott. Brian Elliott.
You know, that file for revocation of the.
No.
Y'all know where Brian Elliott is? Doesn't appear to be here. We issue a bench warrant for Brian Elliott without bond. Justin Hunt.
Sir, I'm sorry. May I be excused? I was here for Brian Elliott.
Yeah, he's the probation officer. I had subpoenaed.
Yeah, you have any idea where Mr. Elliott is?
No, sir, I don't. I've not. I saw him earlier this month during his regular report day, but I've not heard anything from him since.
Well, we'll soon be able to tell you where he's gonna be. He's gonna be in Barron County Jail as soon as he's found, okay?
Okay, thank you, sir.
Thank you for being with us today.
Thank you.
Commonwealth versus Justin Hunt. All right, come on up a little bit. Are you Justin Hunt?
Yes, sir.
This is 23 CR 0033. Were you born in 1980?
Yes, sir.
Last four digits, social security number 3108. DPA represents Mr. Hunt, it says for review, Mr. Stockton, what is this?
Mr. Hunt had a probation violation. He's supposed to be paying restitution. He owes $4,400 initially. And then he was supposed to be assessed for treatment and a little revocation. So we need to know how the treatment going and if he started back making payments on the restitution.
I currently do not have any information. I haven't received anything regarding whether or not the SSC assessment took place. I wonder if Mr. Collins.
What about restitution? What is the record?
Pay $40 this month.
How much is he supposed to pay a month?
200.
Are you in custody?
Well, sir, I speak.
Step away and talk to your attorney if you want
His
to.
officers on the scene, who's Mr.
Yes.
Oh, what is his name?
Probation pro will be with you just a second.
Gary
okay?
Phillips is his name.
Mr. Phillips, you hold on. Mr. Phillips, while you're here, raise your right hand. Mr. Phillips, are you here on Justin Hunt?
I'm here.
Ms. Phillips, okay, I didn't have your picture. Someone else is on there. Somebody else is on the screen. That's Marion County. We'll be with you next, okay? Turn that camera off on Marion County and we'll turn it right back on. Okay, Ms. Phillips, will you tell us what the story here is?
Okay, so Justin Hunt was incarcerated for probation violations in Barron and Monroe County. He was granted contempt, ordered to drug test, and have an SSC assessment. He did report to me and he drug tested. He was positive for methamphetamine, amphetamine, and marijuana. He admitted to use. He was sent to the social service clinician and did do his assessment. He was recommended to attend outpatient treatment at Brightview and Henderson. And Justin advised me he had started Brightview on the 11th of this month. I've been trying to reach Brightview to get verification of that, but I haven't received any yet.
Does he report any employment to you?
He does report that he is working for a private person.
Okay. Okay, thank you. Do you have any questions, this lady?
I don't have any for her, no, Your Honor.
You want to say something else?
Yes, Your Honor. So Mr. Hunt informed me he was just released from custody last month.
When last month?
I'm sorry, Your Honor.
When last month?
Your Honor, I'm not certain of the exact date.
12th, I think.
Around June 12th. He has been working on getting employment back going so that he can start
you
paying
know,
these restitution payments.
I've had it up to here with people that say they're working on getting employment. I ask people up here when they've had their last job and they don't even remember. Now, this restitution is part of his plea.
Yes.
How much is he supposed to pay a month?
Original judgment was 30.
And how much is he paid total?
That can't be right on restitution.
No, it's $200 a month on restitution.
Today it says to the restitution payment is scheduled to be set to the bank. He's paid $2,209.
Out of what?
Out of $4,993.50.
And when was the last time he made a payment?
20th of this month.
June 20th. What do you want to do, Mr. Tucker?
He'll continue his treatment and pay the payments regularly like he's supposed to. He'll be fine.
Is he caught, how much does it take to catch him up? Has he been paying regularly? Well, y'all need to figure out how much he,
I'll be satisfied if from now on he pays $200 a month till this is paid in full.
can you do that?
Yes, sir.
Okay, we'll be on your way rejoicing then.
Thank you.
Do it over in one.
Who is Jamie Piercy? Jamie Piercy. Commonwealth versus Jamie Piercy, 20 CR 0021. Are you Jamie Piercy?
Yes, sir.
Were you born in 1987?
Yes, sir.
Last four digits, social security number 9146.
Yes, Sean.
You're on 20 CR 0021 for review. What does the Commonwealth have to say?
Your Honor, the last time we were in court, you ordered him to pay $200 within a few days of the court day, and another $450 before today or today. And according to Ms. Hill, he's paid $450 online. We cannot confirm that. It's not showing up in the system or anything. He didn't pay it to the child support office. We didn't receive, he allegedly paid it online. My proposal is give it 5 days to show up in the system. If it's not in there, I'll ask for an arrest warrant. It should be ample time for it to show up if it's been paid.
Yes, Your Honor, we have a confirmation number for the payment. It was just made yesterday. We're just waiting on it to show up in the system. Mr. Piercy assures me that he made the payment yesterday.
Well, I tell you what we're gonna do. I'm gonna put him under oath. Let him say he paid it, and if he's lying to me, he can be prosecuted for perjury. Raise your right hand, please. Swear the testimony you're about to give us the truth, the whole truth, nothing but the truth.
Yes, Sean.
You are Jamie Piercy,
Yes, Sean.
and you're saying that you have a confirmation number. Could you read that confirmation number out to us?
The confirmation number is 127-626-260.
And who did you pay that to?
Online,
To who?
the Kentucky Child Support.
Okay,
Website.
so that's your testimony. If that's true, you know, you're in good shape. You continue to make your payments. If it's not true, we'll issue a arrest warrant for you, okay? Seem fair enough, doesn't it?
Yeah.
Okay, thank you very much. Robles? Commonwealth versus Robles? Fatima, is that how you said it?
The team under Jose.
Well, good morning. Commonwealth versus Fatina Robles, 24 CR 0015. Are you Miss Robles?
Yes.
Born in 1996.
Yes.
Last four digits, social security number 6935.
Yes.
Represented by Mr. Gary here for pretrial conference. What we have.
We don't have anything. We're going on for trial.
Yeah, final pretrial conference. We're still negotiating, but it's our final pretrial conference. For motions,
When
we
is
filed
it? When is the trial set?
August 25th or 26th, whatever that Monday is.
August 25th through the 27th.
Yes.
Shit, is this a co-defendant here?
It is.
And are both of them scheduled to be trialed at the same time?
Now, and did Miss Anderson, Gordon Anderson file a motion to sever or not?
No.
Okay.
The 404B notice was filed, but that's only on Mr. Rhodes, so
Yeah.
it doesn't apply.
One time they were contemplating asking to sever this road plat, but if it's not filed, it's not filed.
Mr. Hunley indicated that he might be secured, but nothing's been filed.
Jesse, we can do it now.
Okay.
There's Mr. Hunley.
Road, you got any information on? You filed a motion to sever and
I don't think so.
Okay. Are they both scheduled for trial the same day then?
They are.
It's a joint trial. Okay, well, there would be no reason to do anything else. You've made all your pretrial motions you're gonna make, is that
Yes.
correct? Okay. Good to go.
Thank you, Judge.
Thank you. Danny Sheffield. Danny Sheffield.
he said he would.
But you know, he always says he uses.
You pick it up on the microphone over there. 25 CR 0030. Y'all are picking up on the microphone over there. You are picking up on the microphone. Thank you. 25 CR 0030. Are you Danny Sheffield?
Yes, sir.
You born in 1961?
Yes,
The
sir.
last four digits of social security number 8702.
Yes,
I'm
sir.
here today for the purpose of arraignment. You have a right to remain silent. You have an attorney present with you. The grand jury of Monroe County has returned an indictment charging you with traffic and controlled substance in the first degree, first offense, promotion of drug paraphernalia, possession of controlled substance in the second degree, possession of controlled substance in first degree, methamphetamine, and possession of marijuana. Mr. Bell, you acknowledge the identity of your client, received indictment, waive formal reading arraignment, enter plea not guilty, reserving all pretrial motions.
Yes, sir, Judge.
Schedule this for a negotiation day on the 8th and the next court appearance on the 14th. Both of them are conditions of your bond.
Yes, sir.
Sign a reciprocal discovery order. I'm gonna go over here. I'm gonna go over here to Green River now. If y'all still, if you'll turn, Marion County, excuse me, Marion County, will you turn your microphone, your camera on, Marion County? This is Commonwealth of Kentucky versus Christopher Sutton. Are you Christopher Sutton?
Yes, sir.
You born in 1995?
Yes.
Last four digits, social security 1321. We're here in 24 CR 007, a motion for shock probation. Did the office prepare this, or did he prepare it himself?
Your Honor, I did.
Okay, would you go ahead and present it then?
Yes, Your Honor. Your Honor, the court has a motion for shock probation in front of Mr. Sutton. I would like to call him to testify with regard from what it is that we're asking for today.
You raise your right hand, sir. Swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth.
Yes.
Please state your full name.
Christopher Lee Sutton.
Okay, ma'am, you may, counsel, you may proceed.
Thank you, Your Honor. Mr. Sutton, can you explain to the court what it is that you would, why it is you're asking for shock probation?
Yes, I've been incarcerated for quite some time now. I understand that I broke laws and I've done things in an unruly manner. I probably should have done it a whole lot different. But the time I've been in here has ended up costing not only me, but my family a whole lot of time and money. And mainly just they're losing everything now that I can't really work. And at the moment, I'm also serving time and for Barron County. I'm on a 4-year sentence over there, so I'm in the SAP program here at Marion County. And I know if I got granted shock probation, I wouldn't be able to get out initially. I would have to wait, I guess, until they paroled me out, or however y'all would come to an agreement if they were to shock me possibly.
Okay. And with regard to work, would you be able to get a job if you were to be out of custody?
Yes.
What does your work history look like?
My last job was about 3 years. It lasted about 3 years, and then I ended up coming to jail.
Okay.
If I had not come to jail, I'd still been.
What kind of work is it that you did?
I worked for Alliance Construction. I worked done concrete and construction mainly.
Okay. And if you were out of custody, would you continue working on your sobriety?
Yes, yes, ma'am.
Would you comply with probation?
Yes, ma'am. Always have.
And would that include any recommendation for treatment that the probation office may ask of you?
Yes.
Okay. Is there anything else that you want the court to know?
Not really. I guess. I don't know what else to say at the time.
Okay. I have no further questions.
I'd like a little explanation of what's going on over in Barron County.
Can I ask him just a couple questions?
Sure, absolutely.
Mr. Sutton, how long have you been in the SAP program?
I got here July the 3rd.
And how long does it take to complete it?
It's a 6-month program. They can extend you an extra month or two depending on your your program history, you know.
Okay. And then where, if you got out after, where would you go back to work or would you have a job?
I could call them. I'm not really sure if they'd let me come directly back there, but I'm almost positive with my history and what I know, I can get a job pretty quick.
Okay. I don't have anything else. I would tell you this, Your Honor, this is a motion that was overruled in May. He was in the drug court in Barron County and he was terminated because he had meth on him when he was up meeting with the drug court officer.
I remember that.
Remember that?
Yeah.
And, so you overruled the motion for Shaw. And I don't know if he's even got a shot motion pending in Barron or if he's been ruled on.
So he is still eligible for shock in Barron. Monroe's court date just come around
Let's
quick.
find out what they do over there first.
Okay.
And then if they're, I'm not saying they're more lenient than we are, but they're more lenient than we are. So if they want to give him shock probation since that violation was over there, I'd be willing to consider it by agreed order.
I would too. I would really like for him to complete the SAP program.
Well, that's what would have to be that would have to be a condition of it.
And Your Honor, with regard to the ruling, to the court's ruling, would the court hold this in abeyance?
We're gonna hold it in abeyance.
Okay, thank you.
Okay. We're gonna hold it in abeyance, see what they do to you in Barron County. We'll try to work with you.
Yes, sir.
Let me tell you something, man. If you can do concrete work and stuff, there's a place for you out there, but you've got to straighten your life out. You have to straighten it out or you're gonna end up spending some hard time. You understand?
Yes, sir.
Okay.
Yes, sir. Thank you.
Yeah, thank you, Marion County, for your cooperation. Y'all may be excused.
Thank you.
Yeah. Okay, I'm gonna do a couple more on the live docket. Eli Smith. Eli Smith.
May need it, may not.
Does anybody know where Eli Smith is? Issue a bench warrant without bond for Eli Smith for failure to appear. And now David Wood. David Wood. David Wood, are you here?
You talking about Eli Smith?
Here he comes.
Having come up, he chose up.
Cromwell versus David Wood, 25 CR 0017. You are David Wood. You were born in 1981. Last four digits, social security number 2810.
Yes,
You're here for a pretrial conference. What do you have, Mr. Stockton?
We have a felony plea, Your Honor.
Okay. A motion's been filed, Mr. Wood, that says you wish to enter a plea today. Is that correct?
Yes, sir.
Are you currently under the influence of drugs or alcohol?
No, sir.
Is this plea freely and voluntarily given?
Yes, sir.
You are the same person we just identified in 25 CR 0017.
Yes, Your Honor.
Okay. And you said your judgment is not impaired today. Is that correct?
No, sir.
Okay. Have you discussed this matter with your attorney? Are you satisfied with his advice?
Yes, sir.
Have you viewed the evidence Commonwealth has against you? You feel like you're fully informed about your case?
Yes,
You understand that you do not have to enter a plea today. You have certain rights under the Kentucky United States Constitution. Before I can accept a plea, I need to know that you understand those rights.
Yes, sir.
I'm going to go over them at the end. I'm going to ask you if you understand, okay? You have a right not to testify against yourself. No one can make you say anything. Right to speedy trial by jury. Right to be represented by counsel at your jury trial. You have a right to confront and cross-examine all witnesses called to testify against you. Right to produce evidence. Right to call witnesses in your favor. Have process issued to compel their attendance. You have a right to appeal this matter to higher court if you lose. Right to require the Commonwealth to prove beyond a reasonable doubt that you're guilty of charges against you. Understand that by entering a guilty plea today, you give up all those rights. Is that correct?
Yes, Your Honor.
I may consider the Commonwealth's recommendation, but I may apply any range of sentence provided law. I don't have to accept the recommendation. Prior to accepting your recommendation, I will order wait to receive the pre-sentence investigation report to be done by probation and parole. After reviewing that report, if I decide I do not wish to accept the Commonwealth's recommendation and decide to impose a harsher sentence, you have the right to withdraw your plea of guilty and proceed to trial. Do you understand that?
Yes, Your Honor.
Mr. Stockton, will you, sir, you move to the left just a little bit. Mr. Stockton, what is the Commonwealth's recommendation?
Mr. Wood would plead guilty to possession of a controlled substance, first degree, receive a sentence of 1 year, probated for 1 year, supervised. It would be consecutive to Monroe indictment number 19 CR 108. All evidence in this case would be destroyed. I'm not imposing any work requirement. I don't think Mr. Wood's able to work. I would say he needs to find something to pass his time other than using methamphetamine.
Yes, sir.
So you're talking about an additional year probation?
Yes.
Okay, is that what you agreed to? Is that your understanding?
Yes, Your
Has
Honor.
anybody, including your attorney, offered you any other benefit for the guilty plea? Are you pleading guilty because you did commit the act as amended down in the indictment?
Yes, Your Honor.
You doing so of your own free will because you are guilty for no other reason? Knowing your constitutional rights explained to us is still your desire to have these rights waived and allow the court to fix your punishment when this range permitted by law?
Yes, sir.
You understand that after any of this plea, future convictions on felonies could be enhanced because, as far as range penalties because of this plea?
Yes, sir.
Yeah, I will, ask if that's your signature on the motion there.
Yes, sir.
I'll accept the agreement, order pre-sentence investigation report, order you to come back here on August 14th for sentencing. Thank you very much. Is there, yeah,
Going back to Eli Smith that you just issued a warrant for, that matter was renoticed all this.
okay, let's withdraw the bench warrant for Eli Smith. Now, is there anybody else here alive and in person that desires to come in front of the court on a criminal matter? If not, let's go to the Barron County Jail. Barron County, are you on there? Let me take a quick break here. Yeah. Barron County.
Jesse, I'll waive Steve Brown's appearance. Yeah, so we invest in he wants.
I sent him an order and an email.
Yeah, I'll just waive his appearance. He knows we're continuing it, so.
I'll be do another transport order for next month because it doesn't look like they're going.
I've got a trial next month, so we'll just do it. He's serving state time. In September.
Okay.
We just get you up first and announce it. You come back, it's all.
I'm in no rush.
Yes, I bet you cases to get you started.
Let's call Michael Austin, please. Michael Austin. Are you Michael Austin? Let's turn the microphone over there, Barron County Jail, if you would. Thank you so much. Are you Michael Austin?
Yes, sir.
Good morning, Mr. Austin. You're here on 25-0015 for sentencing. Have you had an opportunity to look at pre-sentence investigation report done by probation pro?
Yes, sir.
That is substantially correct.
Yes, sir.
Mr. Bell, is there any reason this gentleman should not be sentenced today?
No, Your Honor.
On plea guilty to trafficking marijuana, second offense, he shall receive a sentence of 10 years. Upon a plea of guilty to possession of firearm by a convicted felon, he shall receive a sentence of 5 years.
Yes, sir.
The 10 years and the 5 years shall run concurrently for a total of 10 years, serve 136 days. How many days has he been in now?
How long you been in, Michael?
Got 4.5 months.
Where's Mr. Stockton?
He's in the hole, yeah.
Yep.
What's the deal on this firearm here?
Judge, it was found in the house. There was an individual that was taking care of Mr. Austin. I don't know if the court recollects, but he's had a situation where he lost half of his foot. He only got wood heat down there in that country. This guy give us an affidavit.
It should run consecutively with 21 CR 0078, correct? Considering the length of the sentence, I will waive what costs. He's a disabled situation, is that correct?
Yes, sir, Judge. He's supposed to leave straight from there to go into the
Marks,
yes, sir.
Mark Center.
Yes, sir.
Okay, under the sentence, don't have any more guns or firearms around you, man.
All right. Thank you.
If you're somewhere, you need to inquire if they've got it in the car, if they got it in the house, and you just cannot be there. You understand?
All right. Yes, sir.
Okay, thank you very much.
Thank you, Judge.
When am I supposed to go with this?
They'll be sending you a notice. They'll tell you when you go. As soon as they get those days in.
It should be right away.
Should be very soon.
Yeah.
I don't have the count, but the probation pro will count that out, the days out, and they'll get you an order to transport you, okay?
Thank you.
Oh, my lost. Javier Dominguez.
Javier Dominguez, is that how you say the name? How do you pronounce your last name, sir? What's your name?
Javier Moreno Dominguez.
Do you understand English?
No.
He requires an interpreter, Your Honor. We had him in district court.
Do you have an interpreter lined up?
We do not, Your Honor. Once the case has been appointed to us in circuit court, we can get an order over to you to get one.
That'd be good.
Yes, Your Honor.
They don't supply them for court,
Yeah, I know.
the clerk.
So we'll have to get him one. I guess, where, are we anywhere next week? I wanted to get him arraigned. Do you think can y'all call and see if you can get one online now? Just have a seat there. We'll try to get an interpreter for you, okay? Yeah. Jared Hale. Commonwealth versus Jared Hale.
Yes, sir.
24 CR 0092. This is Jared Hale.
I've been informed that defense can't stipulate, so Dr. Sparks is available at 12. He should be on time.
Okay. When y'all will watch for Dr. Sparks, and when he comes on, we'll start Mr. Hale's hearing, okay? Mr. Hale will come back to you in a minute when your doctor gets on there.
And then, Your Honor, if we could take up Stephen Brown, County can't get him on, but Mr. Davis is just gonna get another date anyways.
Your Honor, yeah, I'll waive his appearance. And if we could set it for the September date, Your Honor, he's serving
What
state
date?
time. The September date,
September 18th.
please, Your Honor.
And the negotiation will be September the 5th.
September 5th for negotiation, September 18th. And let the record show that his attorney, Mr. Davis, appeared for him, and we had a problem setting him up with Christian County Detention Center. So,
Yes, sir.
okay, thank you very much.
Thank you, Your Honor. Maybe excuse sir.
Absolutely. Have a safe journey. Herschel Hammer.
Could I address the court about that real quick, Judge?
That Herschel Hammer?
Yes, sir.
Well, sure.
Judge, he is on for revocation, I believe DPA. I was contacted this morning. They asked me if I would request that the court pass him for today and allow me to get ready to try to represent him. I explained to him he would have to stay in jail during that time. They said they were okay with that.
Okay,
So you're entering an appearance officially.
yeah. August the 14th. Your attorney will be to see you, okay?
Thank you, Judge.
Just tell his mother to have all communications through you from now on instead of with me.
Okay. Brian Hunter. Commonwealth versus Brian Hunter. Are you Brian Hunter?
Yes, sir.
This is 24 CR 0004. Were you born in 1992?
Yes, sir.
Last four digits, social security number 3209.
Yes, sir.
Okay, you're here on a pretrial diversion violation. What does the Commonwealth have to say?
Your Honor, if we could speak, the Commonwealth's motion was filed just this Monday. We have not had the opportunity to meet with Mr. Hunter yet. We were going to ask if the court would continue this until next month to give us the opportunity to meet with him and be prepared for a hearing.
Yeah, he was terminated special report for some reason. We were late getting that or late filing it. So
Okay,
we wanted to get it on in case he wanted to move the case.
Okay, we'll hear it today and let it move on if you want to, and if you want to request for August the 14th, okay?
Thank you, Your Honor.
August 14th. Mark Hunter. Commonwealth versus Mark. Are you Mark Hunter?
Yes, sir.
You born in 1977?
Yes, sir.
Last four digits, social security number 8597.
Yes, sir.
You're in 25 CR 0032 for arraignment. You have an attorney?
No, sir.
Did you have one in district court? Did the public defender defend you in district court?
I had a probation violation and she defended me on that. Carried it all over to see. Because they told me they were going to indict me, so we just decided to.
He has had DPA. Yes.
Okay, I'll continue that appointment. Here today, under the indictment, you have a right to remain silent during this arraignment. The charge is distribution of obscene matter to minors, and then persistent felony offender in the first degree, 3 counts. Sexual abuse first degree on a vulnerable victim, 3 counts, and being a persistent felony offender on those 3 counts. You understand what those charges are?
Yes,
I'm
sir.
not asking you if you did it. I'm just asking you if you understand what the charges are.
Yes, sir.
Your counselor, you acknowledge the identity of your client, receive the indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
Sign a reciprocal discovery order. Mr. Stockton, is it too soon to set a negotiation day in this case?
I can set one. I think everything's available on DocuShare at this point in time, is it? So we can.
Except for the victims, child abuse and stuff, but they'll need to make.
Yeah, the only issue is they'd have to make arrangements to view the advocacy center tape for the children's.
September the 5th, is that when the negotiation day is?
It is.
September the, going to do it in August or September?
September is fine with me.
There's a revocation.
Well, that's just have to be put on the same day in September.
Well, let's just do it in August then. What, the negotiation day in August was August the 8th? And the next court day is August the 14th.
Thank you. If you need to agree over this.
Okay.
Commonwealth versus Timothy Jackson. Are you Timothy Jackson?
Yes, sir.
This is 25 CR 0031. Mr. Jackson was born in 1984.
Sir.
The last four digits, social security number 9460. Here for the purpose of the arraignment, you have the right to remain silent. You are represented by counsel. The grand jury of Monroe County has charged you with criminal attempt to commit murder, being a persistent felony offender, assault in the second degree, being a persistent felony offender on that charge, wanton endangerment in the first degree, being a persistent felony offender on that charge. You understand what the charges are? I'm not
Yes, sir.
asking if you did it. I'm not asking if you did it. You just understand what I just said to you.
Yes, sir.
Okay. Counselor, do you acknowledge the identity of your client received the indictment, waive formal reading and render in a plea of not guilty, reserving all pretrial motion?
Yes, Your Honor.
Mr. Jackson, I'm signing a reciprocal discovery order that requires the Commonwealth to present your attorney the evidence that they have help prepare you for your defense. We'll have you back here on August the 5th for a negotiation day. No, correct that. August the 8th for a negotiation day and August the 14th for your next court appearance. Both those are conditions of your bond. Okay, thank you very much. Ethan Lynn. Are you Ethan Lynn?
Yes, sir.
Good morning. We're here on 25 CR 0026, Commonwealth of Kentucky versus Ethan Lynn. Mr. Lynn, were you born in 1990?
Yes, sir.
The last four digits, social security number 8958.
Yes, sir.
We're here on 25 CR 0026. What does the Commonwealth have to say about Mr. Lynn's case?
Judge, I've entered my appearance in this case as conflict counsel. And I have spoken with the Commonwealth about him.
What's the Commonwealth have to say?
Well, I recall having a conversation.
Come
She was
around here
gonna
when
be-
we get you on the camera if you don't mind.
I recall having a conversation saying you were going to be representing him. I don't know that we've negotiated the case. Is that correct?
That's correct. You sent me the discovery, and I think maybe even we talked about what the offer might be. But he has cases also in Barron and in Metcalf. So I'd
Be here
also,
on August the 8th for negotiation.
that'd be
next-
fine.
And August the 14th is the next court date. Both of them are conditions this bond. You need to be here and we need to get a transportation order. You need to submit a transportation order for both those days, okay?
I'll submit an order, Judge. Thank you.
Thank you. Larry Norris.
What do we need to do?
Are you Larry Norris?
Yeah.
Good morning. We're here on 23 CR 0078. Mr. Norris, were you born in 1992?
Yeah.
Last four digits, social security 1833. We're here on a probation revocation. What's the Commonwealth have to say?
This is another one. Mr. Norris was just recently arrested on June the 27th. So our motion was filed this week, I believe. So we're ready to proceed. But I don't know if Ms. Hill is or not.
I'm not, Your Honor. We were going to ask to pass this into August. I have looked at the violation report and I do want to speak to Mr. Stockton
You
about
want a
potential.
negotiation day?
Yes, Your Honor.
August the 8th is the negotiation day and August 14th, the next court appearance. Your attorney will be over to see you, Mr. Norris. Jose Robles. Yep. Commonwealth of Kentucky versus Jose Robles. 23 CR 0050. You are Jose Robles.
Yeah.
Okay, you represented by Mr. Garrett. You were born in 2000, the last four digits, social security number 4313. Now, we don't have but one other case. I guess we're waiting for an interpreter. Is that correct? And then waiting for the doctor to get on the competency hearing.
And then we have Mr. Louise, who is the process.
Yeah. It's time to have the 404B hearing, but we'll wait till we have to get Mr. DeWeese. Where is Mr. DeWeese? There he is. Call Mr. DeWeese, come back up here and then we'll get to your case.
That's fine, Judge.
Judge,
Yes.
I'm full of work. The Commonwealth's just hardly notice because we know that you
Okay. Okay. Commonwealth versus Christopher DeWeese, 25 CR 0028. You are Christopher DeWeese. You have an attorney? Did you have one in district court?
Yes.
Okay, I'll continue that appointment. You're here for arraignment. You have a right to remain silent. The grand jury Monroe County charged you possession of controlled substance in a first degree methamphetamine. Counselor, you acknowledge the identity of your client, received indictment, waive formal reading and arraignment, enter plea of not guilty, reserving all pretrial motions.
Yes, Your Honor.
It will set the list for August the eighth for negotiation, August 14th for the next court date. What is his bond?
Bond on this is 15,000. Go on, the person who's running the drug test.
Okay. Do you have anybody that can make your bond?
They posted.
How much was that?
It was 2,500.
How much is that? Yeah, I'm not too, where have you been since district court?
At home,
I mean, so you've been here in the county?
Metcalf County,
I'm just asking.
No,
I'm
I
not
mean-
accusing you of anything.
No, man, I'm saying I live in
I'm
Metcalf
what I'm
County.
yeah, I'm trying to find out whether you've been trying to elude us.
No, sir. No, sir. I didn't.
Well, I'm not accusing
Okay, no, I'm
you.
just saying, no, sir, I haven't been.
Calm down. You're fixing to be all right.
Okay. Service.
Since he did show back up, I'm gonna let him out on the same bond
Thank
that he was, and you'll be here on August the eighth for a negotiation date at 9 a.m. and then August the 14th, and be in contact with your attorney before then, okay?
Thank you very much.
Okay.
Thank you.
Yeah, yeah. Okay. Did we get any luck as far as interpreter is concerned? They're working on it, so we'll come back on the interpreter. The doctor is, what time is the doctor supposed to be on for the competency hearing?
12 o'clock.
Okay, so we still got some time there. I would assume it would be 12 o'clock our time, 1 o'clock their time. Is that correct?
Correct.
So let's start the 404B hearing on Mr. Robles. There was a motion for 404B. Is there any objection?
There is, Judge.
Okay, what's your objection?
Judge, Carry 404B basically says that propensity evidence should not be used in the case in chief by the Commonwealth.
Okay, wait a second. We need to move everybody on out. You're picking up on the microphones, okay? Now go ahead. Do you have objection to 404B?
I do, Your Honor.
Okay,
So
we'll let Mr. Stockton first. You handle this, Mr.
Well, I will up to a point, and then Anne Marie is gonna, if we have to have testimony.
Well, I just want a quick presentation of what you propose to introduce to come around. We need to go send for her.
I think Jesse may have went to get her, Judge.
I don't know what his objection is first.
Well, I want to know what it is before I hear I want to hear what y'all are trying to present first, okay? What 404B evidence are you seeking to introduce?
Believe without having the motion, notice in front of me, there was 8 different acts that we have given notice on, all pertaining to the same individual that they were against, which was which is Haley King. She's present. She was the paramour to Mr. Robles. And
Were these acts of domestic violence?
Yes, they were.
Had they been charged? Or was
I
it
believe
EPO?
2 of which had been. The other ones are, in some of the acts, she had also filed a protection order against him regarding where she had alleged those acts, and they had later on been dismissed. And then a few of the other acts are just ones that were unreported.
Yeah, okay. And what is your theory as to why these should be admitted under?
Judge Haley King is not alleged to be a victim in this case. I'm sorry. Haley King there are no charges basically as a result to her. Despite there was an argument between them or they were talking, there is no charges that where she is indeed the victim. What I would object to, Judge, is, this is straight propensity evidence, which is under the rule, it can't be used unless it's used for one of several purposes. What we didn't hear was for which purpose does the Commonwealth seek to use it? Now, I would bet that their comment may be that it shows a pattern, but the pattern is the exact pattern in this particular instance would be propensity evidence to show that there were disagreements between him and another person, that there was allegations of domestic violence. And again,
Now, what is, Mr. Robles was a former paramour of this Haley King, is what you said. Is that correct? And the victim, what relationship did the victim have to Haley King?
Sister.
One of
Well,
the,
actually, it's,
yeah, one of the victims, Austin King, which is subject to the attempted murder and assault first, he was a brother to Haley King. And then the victim.
Is he deceased now?
No, he's alive. The victim that's deceased was living at the residence, residing part-time with at Haley King's residence, which is where this took place. And he was in a relationship with Haley's sister, who also resided at the residence. The reason why we believe these acts are necessary for trial or part of the trial is because they give a background as to why these two individuals, the two victims, were in the position that they were the day that this shooting happened. And also it gives a background as to why everybody was on guard that day on behalf of Haley King and why it took place at her house. So without explaining or showing as to why everybody was in the situation that they were that day, we can't do that without giving the background information as to the relationship between Haley King and Jose Robles.
so again, Judge, under the rule, giving background information is not one of the permitted uses for this sort of information. I can speculate that they might reach for pattern, which would be the closest of all of those that are listed for which they could use, but even that fails. But it fails as well because the target of the domestic violence was towards a person who is not listed under one of the charges as being a victim. So essentially, we're taking some prior bad acts, alleged prior bad acts on the part of Mr. Robles.
Was the person who was the object of the protective order, was that person present?
Haley King?
Haley King, was she present when this happened?
She was.
Well, here's the thing that gets me, this language about being intertwined. You know, it appears to me that there's gonna have to be some explanation of what Mr. Robles was doing over there on that day. Now, if as far as the detail going into these particularities of what happened on each one of these prior occasions, it would appear to me that if you don't have some context to what was going on over there about what had happened previously and about his propensity for violence, and these people evidently stood in to protect Miss King. Is that what they did? That's what your theory is, right?
That's part of it. Yeah, I believe that's.
Well, I mean,
Yeah.
it is part of it.
And one of the acts specifically was an assault on Miss King, and that he had been picked up on in June of the same year, so a month prior to this murder. And part of the bond that was set for him, he was to have no contact with Haley King, and he was at her house when this happened. So, you know, all of these acts combined show, you know, they're so intertwined with the background as well as just why everybody, especially the victims.
Did you file a written response?
I did not, Judge.
Okay.
But I would like to add one more.
I'm going to give you an opportunity to file a written response. I'm inclined to think that it would be impossible to set the stage in this situation if there wasn't some explanation of why these people felt like there was a necessity or a need to defend her. It could be that maybe they didn't have a right to defend her. Maybe he had a right to claim self-defense against them or whatever. So I don't think if we don't set some context for this stuff, I don't see how we can present it.
Judge, if I might just add a little more just to the record.
Well, why don't you just put it in your response for the record, okay? But you can say, go ahead, you can say a little bit more.
The other test is, even if you were to find that there was some specific purpose, or if it's inexplicably intertwined, to basically present a story, the other test is it has to be more probative than it is prejudicial.
Always the test.
And I would suggest to the court that this is like pouring gasoline on the jury to cause them to find him guilty of the offense of murder and assault first. So I think it's extraordinarily more prejudicial than it needs to be. And that outweighs its probativeness. The Commonwealth could just as easily substitute the words for they had a troubled past without going into all the details, because it's the details that would cause this case, I believe, to come back on appeal.
Well, it appeared to me that for the purposes of transparency in a case like this, you have to know what the disagreement between these parties was about and put it all in context, as to why there was some fear of him, why they would have raised the defense of her, why maybe why they may have exceeded the authority that they would have had to defend her, whether, there's always this initial aggressor and someone who pulls away and all. I can see, I don't know anything about the facts of the case, but it appears to me that all of those sort of things could play into the thing. So I'll let you brief it. Is this scheduled for trial?
In August.
Oh, late August, Judge.
Okay, let's give you 10 days to brief it and let y'all have 10 days to respond, okay? And then I'll make a ruling. And you might suggest, if you might say, doing an alternative pleading, and the alternative, if instead of letting all of it in, what you suggest would be admissible. And you need to put in there what you think, of course you want it all in, but if it wasn't all in, I'm sure you can get Mr. Hunley to offer some compromise on the thing, see what it has to be in.
Jesse would do the compromise, not play.
Yeah, well, in any event, if y'all could do that, it would help me get along on this thing, because I really don't know. I read these acts in your motion. I really don't know how much into the detail of each one. We don't want to retry these things, but we want to give the jury a flavor of what everyone was going on. So you might very well be able to come up with some limiting language somewhat that might be acceptable to the defense, without going into these things. But I think the repetition of these acts indicates the creation of a hostile atmosphere that could well have affected the judgment of the people that end up being victims, or the defendant from his perspective. Okay, well, thank y'all very much.
Thank you, Judge.
Yeah. Okay, we have an interpreter on the line here. Are they on Zoom? Where are they? On the phone. We'll see where we can send a Zoom, where she can hook up a Zoom with us, okay? Megan, what's the address you want? We need to just.
Usually it's just the call, the audio.
You know what to tell a woman about how to get on Zoom? The interpreter.
Get on them.
I'll agree with just a minute. Megan, you want to come around and help?
They
her?
haven't spoke to the interpreter yet, so they
Oh,
don't
you
know if
haven't
she can
spoke-
get on.
you
Zoom.
haven't-
Skip there on the phone, but she's trying to transfer opinions.
Okay, we'll be back with you as soon as we get the interpreter. Bring your grand jury in.
We don't have a spot.
I didn't bring it. I thought everything was continued to 31st.
Okay.
I misunderstood you when you said it's continued.
Does this thing?
Yeah, y'all come in and take the seats. You can sit there, you can sit there if it's more convenient for you, sir. Okay, everyone can be seated. Who's the foreperson of the grand jury? Matter Foreman, have 9 or more of you agreed on the actions you're taking back there?
Yes, sir.
Okay, will you present that to bailiff and let me examine?
Yes, sir.
Okay, thank you. Okay, ladies and gentlemen of the grand jury, everything appears to be in order here. I've just signed a document that will either create the summons or warrants for the people that you have charged in your report to me. I want to encourage everyone to know that it's important that you remain confidential on anything you hear in there, any actions you've taken, because sometimes people decide to get scarce if they find out they're indicted and they cause some kind of problem if there's a confrontation, and we don't want any problems or confrontations. The next time that you are to be here is on August the 14th, unless you're called back in because of an emergency or an insurrection. And these days, you can't ever tell when you're going to have a good insurrection happen anywhere. It could happen, but we hope we don't have one in Monroe County. Thank you for your service, and we'll see you on the 14th. All rise for the grand jury, please. Hey, do we have the interpreter lined up yet? Well, we can try it. Okay, put her on the speakerphone. Yeah. I don't know how this is gonna work.
SID, Binks, PhD. Let's put Sid Binks, PhD.
Yeah.
Hello?
Hello.
Are you the interpreter?
Yes.
Okay, we have a gentleman that's in jail. We have him online here. His name is Javier Dominguez, Domingez. So
okay,
he's in front of me now on the screen. Sir, will you raise your right hand?
Hola, buenos días, señor. Yo voy a ser la intérprete entre usted y el representante. ¿Pudiera levantar su mano derecha?
You swear the testimony you're about to give is the truth, the whole truth, and nothing but the truth.
¿Usted jura que el testimonio que va a dar es la verdad, toda la verdad y solamente la verdad?
Sí, claro.
Okay, you have the right to remain silent with the exception of the questions that I'm going to ask you about your identity. Do you have an attorney?
Muy bien. Usted tiene derecho a permanecer en silencio, a excepción de las preguntas que le voy a estar haciendo sobre su identidad. ¿Tiene usted un abogado?
Sí, tengo una abogada.
I'm really sorry, but I'm not able to hear.
Would you speak up a little louder? Sir, will you speak louder?
Perdón, señor, no le escuché.
Sí, tengo una abogada.
Yes, I have an attorney.
Okay.
It was us at district court.
Okay, the public advocacy is reappointed to this. I'm going to read the indictment charge. He has a right to remain silent.
Muy bien, le voy a estar leyendo su acusación. Usted tiene derecho a permanecer en silencio.
Were you born in 1995, sir?
¿Usted nació en 1995, señor?
Sí,
Do you have a social security
Yes.
number? Do you have a social security number?
¿Tiene usted un número de seguridad social?
no tengo, solamente lo perdí en la escuela.
¿Perdón?
No tengo.
I don't.
Okay. You're here with the purpose of arraignment. I'm going to read the charges against you. You have a right to remain silent.
Muy bien. El propósito de que usted esté aquí es la lectura de sus cargos. Le voy a leer la lectura de sus cargos. Tiene derecho a permanecer en silencio.
Sí.
Okay. The grand jury of Monroe County has charged you with burglary in the second degree,
Muy bien. El gran jurado del condado de Monroe lo acusa de hurto en segundo grado.
and also with theft by unlawful taking or disposition over $500 but less than $1,000.
Sorry, Honor. And also
Okay, theft by
of unlawful.
Theft by unlawful taking or disposition over $500 but less than $1,000.
Thank you very much. Y también lo acusan de robo no legal, que es tener o disponer de cosas que sean mayores de un valor de $500, pero menos de $1,000.
Okay, counselor, do you acknowledge the identity of your client?
Asesor, ¿usted reconoce la identidad de su cliente?
Yes, Your Honor.
Speak up, she didn't hear you.
Yes, Your Honor.
Sí, su señoría.
Waive the receipt of the indictment,
Exonero el recibo del dictamen.
waive formal reading and arraignment, and enter a plea of not guilty.
La lectura formal y el ingreso de una declaración no culpable.
We will set a negotiation day for August the 8th, and the next court appearance is August the 14th. And on that date, we will ask the clerk's office to have an interpreter present here. And you shall also have your own interpreter for the defendant, so you can have private conversation with him. Will you inform the defendant of that, ma'am?
Okay, sorry. The next appearance will be on the negotiation will be on August 8th, but the next appearance on August 13th.
Right. And an interpreter will be present for him and with the public defender, so he can privately discuss this matter. And there always also will be a court interpreter separate from that, okay?
Okay, perfect, thank you. Muy bien, le comento que vamos a establecer una negociación para el día 8 de agosto y su próxima comparecencia va a ser el 14 de agosto. Se le va a estar proporcionando un intérprete por parte de la oficina del secretario y también se le va a proporcionar un intérprete para que usted pueda platicar este tema con su abogado.
I'm signing a reciprocal discovery order, which will require the Commonwealth to provide your attorney with proof to get prepared with your defense.
Sorry, Your Honor, I need to be able to write down at least keywords, and I cannot write down as fast as you talk.
Okay, well, I'm the first person that's ever accused me of talking fast, and I appreciate that. I just signed a reciprocal discovery order, which requires the Commonwealth to provide information to the defendant to prepare for his defense.
Perfect, thank you very much. Muy bien, voy a firmar una orden de descubrimiento recíproco que requiere que la mancomunidad provea al acusado lo necesario para que se pueda presentar su defensa.
Your attorney will be to visit you within the next few days with an interpreter.
Su abogado lo va a estar visitando en los próximos días con un intérprete.
Thank you very much.
Muchas gracias.
Thank you, Madam Interpreter. You are excused.
You're welcome, Your Honor.
Yeah.
Have a nice day.
You too. Now, your doctor is supposed to be on in 45 minutes.
No, I just told Ms. Thompson, we called, he's supposed to be on in 5 to 10 minutes.
Okay.
We also have a show cause donkey that was supposed to be 11.
Okay, you give me the show cause docket here. Show cause docket. Commonwealth versus Truman Adams. Okay, he owes $620. Have him arrested and he can purge himself by paying $620. Damon Hurt was he here today? 43,601. When was the last time he made a payment?
Yeah, he's made a payment, they continued him August 14th.
Okay. Diego Morales owes $140. Issue a bench warrant and purge himself by paying $140. Dylan Reed Russell owes $185. Hadn't paid anything. Issue a bench warrant and purge himself by paying $185. Southworth, Aaron Southworth owes $1,107, and that's restitution, is it?
Yes.
Having to pay issue a bench warrant and purge himself by paying $500 of that, okay?
Hey, Jan, I just noticed on the docket, it's notated on there that he made $100 payment on July 11th.
Did he make a payment on July the 11th?
Yeah, we just had that, sorry.
August 14th, and that's on Aaron Southworth. August 14th. William Chad Starks owes $8,971. When's the last payment he made?
Okay, back in June.
Is this restitution?
Yes,
How far behind is he on the restitution?
he spent it today, for the most part, we need another.
Okay, let him pay, issue a bench warrant and purge himself by paying $200 and then continue the regular payments. Okay?
If you submit Joe Ferry. Supposed to pay $250 a month plus 30, he just paid 170, anytime he needed to pay.
What page on the docket?
I tore him off because he had paid.
Okay.
Because his code payments are paid through PT, but he's not.
Do what?
His code payments are paying what they're supposed to pay.
Well, how much has he paid?
He paid 170, but he's supposed to have 280.
Well, issue a bench warrant for him to make up the difference. Okay,
I think he's here, Your Honor.
what's his name?
Joby Grace.
Joey Graves, you wanna come around?
Joby Grace.
I don't know.
How about this one?
State your name, please. Hey, spell your last name.
GRACE.
Okay, what's the deal on your restitution payments?
I made a payment yesterday, $170. I just was short from work from the rain stuff and had bigger pay done. But I've been making regular payments every month.
Yeah, how much short is it?
I can have the rest of it Friday.
Yeah, I'm going to give you a little bit more time than that. Be caught up into
It's 110 short.
110 in 10 days, and then make your regular payments after that, okay? Okay, thank you. Thank you for coming. Does that complete the show cause docket? Okay, as soon as we get the physician on, we'll go back to Jared Hale, is that correct? Okay, we're back on Commonwealth versus Jared Hale, 24 CR 0092. You are Jared Hale, is that correct? Are you Jared Hale? You have to speak up, Mr. Hale.
Something's going on, they don't have any audio.
See if they'll help you put the microphone on there, Mr. Hale.
Yes, sir.
Okay, were you born in 1984?
Yes, sir.
Last four digits, social security number 9494.
Yes, sir.
Okay, the Commonwealth has filed a motion for a competency hearing, is that correct?
Yes, Your Honor.
Okay, do you have a witness?
Yes, Dr. Sparks, Your Honor.
Dr. Sparks, thank you for joining us today on short notice. Will you raise your right hand, please? You swear the testimony that you're about to give is the truth, the whole truth, and nothing but the truth, so help you God.
I do.
They state your full name and your credential.
Stephen Anthony Sparks, PhD. I'm a psychologist and a consultant with the Kentucky Correctional Psychiatric Center, KCPC.
Okay, Mr. Stockton, you may proceed.
Dr. Sparks, how long have you been associated with KCPC?
With KCPC for about 16 years. I've been working as a forensic psychologist for 20 years.
Okay. And did you receive a court order to evaluate Jared Hale as regards his ability to stand trial, his competency to stand trial?
I did.
And what type of approach did you do and use in that evaluation?
This was completed by video conferencing while Mr. Hale was at the detention center and I was in my private office.
Okay. And was Mr. Hale subjected to any type of testing, and what kind of review did you do prior to rendering an opinion?
Yes, prior to meeting with Mr. Hale, I reviewed what I had at my disposal, which included the court order, offense-related law enforcement reports. Also, we have one of our staff members at KCPC will call the detention center and do an interview. They'll write a brief report. So I was able to review that report as well. I also had the Kentucky Court of Justice. I had his criminal history record. I also had records from the jail. I then met with Mr. Hale. I completed an interview. I asked him about symptoms. I asked him about his history. We talked about what happened at the time of the alleged offenses. He also did complete some psychological testing. Following my meeting with Mr. Hale, I was able to conduct a telephone interview of his mother. It was upon that information that I based my opinions. Now, since that time, I've also received records that I reviewed from Life Skills and from Western State Hospital. My standard is if records I receive change my opinion, I send an addendum to the court. If they are supportive of my opinion, I don't. I review them. So I have reviewed additional records. I felt they were supportive of my opinions.
Okay. Based on a reasonable medical probability, then what is your opinion as regards Mr. Hale's ability or competency to stand trial?
To a reasonable degree of psychological certainty, it's my opinion that Mr. Hale does have the capacity to appreciate the nature and consequences of the proceedings against him, but that he lacks the capacity to participate rationally in his own defense.
Okay. What is that opinion based on, Dr. Sparks?
Well, I guess the simple answer would be all the different things that I mentioned I was able to review. I think the more specific answer would be, I think there were a number of pieces of evidence that would suggest he is experiencing psychological symptoms of psychosis. Now, I met with Mr. Hale. He was very pleasant. He was very straightforward. He was very articulate. I appreciated all of that. I know he would likely disagree with this. However, I think the information taken as a whole, I was able to interview his mother, who said he had been experiencing various symptoms, including likely delusions and hallucinations. He had reportedly gotten a diagnosis from Western State Hospital suggesting some psychosis, and that was confirmed when I received those records later. Also, I did not have at the time, but Life Skills also provided such a diagnosis. I had listened to various interviews and video recordings of the identified victim and others in this case, and one of them had also suggested that he had been experiencing auditory hallucinations. I conducted psychological testing that suggested likely paranoia. And of course, when I met with him, I spoke with him and he made a number of statements that I believe suggested hallucinations and delusions. So based on that information, I felt he was experiencing a psychosis. Now, more specifically with regard to his competency, I think that his understanding, his experience of these symptoms is directly related to events that occurred at the time of the alleged offenses, the various players, and I think it affects his decisions he would make regarding legal strategy, how he would approach his case. So I do think that in this case, these symptoms would interfere with his ability to participate rationally in his defense. I'm sorry that was so long-winded.
Oh, that's all right, doctor. My question then is, after reading your report, it appears that you believe that this psychosis can be treated and thereby enable him to be able to participate in his defense. Am I phrasing that correctly?
Yes, that's correct.
Okay. And you would have to have him then transferred, I guess, or brought to the psychiatric facility at KCPC so he could be treated in-house?
That's exactly right. At the present time, to my knowledge, in Barron County, there is no outpatient competency restoration treatment. We're gradually trying to get that happening across the Commonwealth, but at the present time, there is not. So yes, I would recommend treatment with the experts at KCPC.
Okay. Now, in your report, you put in it for a foreseeable future, there's a probability of competency in 360 days, but I think the statute provides we can send him up for a total of 60 days. Do you think that would be enough to restore competency possibly?
I do. In fact, I've worked in-house at KCPC for over 10 years, and I found that usually in the majority of cases, these types of symptoms I think he's experiencing are treated within 30 days. And sometimes the folks at KCPC will request an extension to go to 60 days of the court, but usually restoration will happen in that period of time.
So a court order for 30 days would be sufficient, you believe, and then you could request additional time if necessary?
Yes.
Okay. I have no further questions.
Judge Williams, can I speak a second?
Wait just a second. I'll give you a chance in a minute.
Mr. Hall, I would advise you not to say anything, but I do have a couple of questions for Dr. Sparks. Dr. Sparks, can you say with a reasonable degree of certainty that KCPC will be able to restore Mr. Hale to competency?
I think there's a substantial probability. I think if we look at the national averages of people who are undergo competency restoration treatment, approximately 81% will be restored to competency. I don't see why that would not be the case for Mr. Hale. Actually, I should say, I think what he is experiencing to some degree is delusions. Delusions can be more difficult to treat. Nonetheless, I think it falls under the umbrella of psychosis, and I think that is very treatable. And I'm not an MD, I'm a PhD, but I'm aware that there are very specific medications and treatments for these types of symptoms.
And does KCPC have the ability to address like the ability to prescribe those medications?
Yes.
Okay. I have no further questions.
No, no.
Okay, do you have any other witnesses?
No.
The doctor could.
Sir, can I like, please?
Wait just a second. I'm gonna get back to you here, okay? On an aside, who is responsible? Who's the head of KCPC now?
At this point, it's Colleen Slusher. Dr. Colleen Slusher is our chief executive officer.
Okay, could you have Dr. Slusher call me on another matter? I have trouble getting through up there. I call Judge David Williams, and I'm in the directory, okay?
Yes, of course.
Thank you. May be excused. Now, sir, you act like you want to say something, but your attorney has advised you not to say anything. You realize you have the right not to say anything, correct?
Yes, but I would sure like to speak about something because I don't understand what cattle crossing a fence and me going over
Jared,
my
Wait, we can't talk about the facts of the case. The issue we're trying to decide now is whether you're competent to have a trial so you can tell your side of the story, okay?
I just don't understand why I've been in here for 10 months and with a $10,000 cash bond on cattle crossing a fence where I've never stolen up for in my life. My mother and father come to my house and took my
don't say anything else about the case. I'm inclined to let you
understand. It don't make no sense to me.
Wait just a second.
Based on Dr. Sparks' opinion, that's the only thing in the record. I think if we have a trial, it's going to be overturned. It's going to be reversed. Because the only evidence in the record right now is he's not competent to stand trial. I'd love to go ahead and have a trial too and get it over with, but
I would.
What do you have to say, Representative?
Judge, Mr. Hale does not believe that he has any type of mental illness that would prevent him from rashly participating in his own defense. However, I believe that the court has heard testimony today, and while the defense would ask for the court to not send him to KCPC, I do agree with Mr.
To not, to do what?
To not send him to
What
be
do you
restored.
suggest I do with him if I don't send him for evaluation?
Judge, I do not have a suggestion in the alternative other than to state that the defense does agree with Mr. Stockton that this would be an issue preserved for appeals. I have concerns that we would be doing a trial twice.
Well, what do you suggest we should do then?
Judge, I do not have a suggestion.
But
Sir, I've been sent to Western State 2 or 3 times and life skills afterwards, and Heather and Ashley Cole of life skills of Monroe County Life Skills told me that there was nothing wrong with me. It was my neighbors, Corey Nixon, and them was causing me the problem.
Jared,
don't
please
say
stop
anything
talking.
about your case. Don't say anything else about your case, okay?
Yes, sir.
I would suggest the order be entered for 30 days treatment, restore him to competency. We've got 3 cases to try, not just one. Once he's restored to competency, Commonwealth will make an election while he's at KCPC. And if he wants a quick trial date, we'll accommodate him.
Okay, I'm gonna order a 30-day treatment so that it's protected. Okay, thank you very much. Okay, thank you, sir. Your attorney will be over to talk to you.
Yes, sir. Thank you.
Okay, you have a great day. Okay, does that finish the criminal docket?
Yes, ma'am.
Okay, let's go off the record then. Thank you. Everybody have a seat. Here, we're gonna do the child support docket here. Cleary versus Cleary. Swear the testimony about to give us the truth, the whole truth, nothing but the truth.
State your name for the record, please.
Sarah Duncan.
You need to speak up a little bit, okay?
Okay.
You're employed by the Monroe County Child Support Office and you're familiar with the case of Melina Cleary versus Preston Cleary, 17 CI 177. Is that correct?
Yes.
Mr. Cleary is he the payor?
No, she is.
That's what I thought. Melina Cleary is before the court given notice of this hearing. As far as you're aware, she's an able-bodied person capable of providing this support. Is that
Yes.
correct? She's neither incarcerated nor a member of the armed force. Is that correct?
Yes.
And she last made a payment on April the 18th, 2025.
Yes.
She has an arrearage as of today of $7,739.60. Is that correct?
Yes.
Judge, we'd ask you to hold her in contempt, allow her to purge by making a lump sum payment of $1,250 and pay back here. August the
You want me to have an arrest warrant issued for her? or-
Just contempt. This is
Okay.
just,
And purge yourself by when?
August 14th.
Okay. Okay, you electronically submit that order? Okay. Comer versus Comer.
Ms. Guppy, you're still under oath. You're familiar with the 21 CI 44 Jeffrey Dale Comer case. Is that correct?
Yes.
And he is before the court given notice of this hearing. As far as you're aware, he's an able-bodied person capable of providing this support. He's neither incarcerated nor a member of the armed force. Is that correct?
Yes.
He has an arrearage of $618.70 as of today. Is that correct?
Yes.
And he was paying fine until April 4th and he just quit paying. Is that correct?
Yes.
Judge, we'd ask you to hold him in contempt. The judge's arrearage of $618.70. Allow him to purge by making a lump sum payment of $125 and then appear back here on August 14th. So
Okay.
he's purged and
Submit the order. Crawford versus Crawford.
continue until August the 14th.
Russell versus Curtis.
August the 14th.
Fox versus Fox.
August the 14th.
I wrote it
please.
down.
$3,895.
Well, I know this case has been going on for 13 years, so. Yeah, it's 12 cases, but exactly 13 years. Graves versus Graves.
August the 14th, please.
Turner versus Geffen.
August the 14th.
Hammer versus Hammer.
Ms. Guppy, you're still under oath. You're familiar with the case of Courtney Hammer versus David Hammer, Monroe Circuit Court 18 CI 118. Is that
Yes.
correct? Mr. Hammer is before the court given notice of this hearing. As far as you're aware, he's an able-bodied person capable of providing support as previously ordered. He's neither incarcerated nor a member of the armed forces. Is that correct?
Yes.
He's not made a payment since September 19th, 2022. Is that correct?
Yes.
And he currently has an arrears of $13,232.06. Is that correct?
Yes.
Judge, we'd ask you to judge the arrears, hold him in contempt, allow him to purge by making a lump sum payment of $2,000 and appear back here August 14th.
Okay, submit the order. Hassett versus Hassett.
August the 14th.
Taylor versus Houchins.
August the 14th, please.
Hudson versus Hudson.
Continue to August 14th for review, please.
Jimenez versus Jimenez.
Continue this one also to August the 14th.
Joyner versus Joyner.
Ms. Guppy, you're still under oath. You're familiar with the Sarah Joyner versus Kenneth Joyner, Monroe Circuit Court, case number 16 CI 79. Is that correct?
Yes.
Mr. Joyner is before the court given notice of this hearing. As far as you're aware, he's an able-bodied person capable of providing the support as previously entered. He's neither incarcerated nor a member of the armed forces.
Yes.
He has an arrearage of $26,946.13. Is that correct?
Yes.
Last made a payment in February of this year. Is that correct?
Yes.
Judge, we'd ask you to judge his arrearage, hold him in contempt, allow him to purge with making a $1,500 payment towards that arrears, and appear back here August 14th.
Okay, submit the order. Dye versus Jones.
Continue to August 14th.
Jones versus Jones.
Continue to August 14th.
Page versus Page.
August the 14th.
Pennington versus Pennington.
August the 14th.
Rich versus Rich.
Ms. Guppy, you're still under oath. You're familiar with the case
Just
of Rich?
Mr. Rich back there.
Yeah.
Mr. Rich, you want to come around?
Judge, prior to today, he had a.
Wait till he gets up
Okay.
here with him. You Sean Rich?
Yes, sir.
Good. Okay, go ahead. We can hear now.
He had an arrearage of $1,350. He made a payment today of $260, which would reduce his arrearage to $1,090. We would also ask that you still find him in contempt for not making the payments as previously ordered. He has an arrearage, like I said, now of $1,090. Make a $225 lump sum payment plus keep current with his current support and make a monthly payment towards the reduction of arrears. Appear back here August 14th.
When do you want the 225 paid by?
On or before August 14th.
Got that? Make you ready?
They will send you a copy. We'll have to submit a different order because we're changing the amount of the arrears.
Okay, they'll send you, what's your mailing address now?
Excuse me.
Make sure they get your correct mailing address.
Okay, okay.
What is it?
It's what y'all have. It's
Okay.
4177.
Okay, thank you so much.
Yeah.
Okay,
thank you.
good deal. You're Smith versus Smith.
Continue to August the 14th, please. Your-
Okay, so that concludes your docket.
That concludes the child support.
Okay, thank
very
you.
much.
Thank you very much. Good to see you. Civil docket. Okay, the civil docket, geoscience consultants versus driver.
Mr. Anderson's here for the back today.
That's right.
This is to assign a bench trial.
No, I don't think I want to do a bench trial on this thing.
Okay, then I would ask that you dismiss the case.
We would pose that motion.
I don't really like bench trials. I mean, the reason I don't like bench trials is I know nothing about this case. I have no prejudice one way or the other. But it appears to me that after it's over, that people that participate aren't as satisfied as they are if they get a jury trial to let 12 people decide instead of like one old guy decide who owns the property or something like that. What are the issues to be tried? And let me see if they're amenable to being tried by a jury. Let's break down just the issue or two.
Wes would probably know more about the facts of the case, but I will say this after talking with Brian briefly this morning about it, is he thinks that the facts are going to be relatively straightforward. He thinks it's more going to be just come down to a legal conclusion.
Thank you for his confidence.
So he's
Tell him I don't care.
Okay, all right, all right.
It's a mechanics lien. And through the discovery process, most of it was accrued by two owners previous.
Oh, it's the one where they paid the wrong party allegedly. Is that this case?
Yeah.
Geoscience had contracts with two separate estates.
Yeah.
So it's.
And the state of Kentucky.
This was Barry Tanks or something, was it? Barry
It's
Tanks.
issued a $20,000 payment to the estate of, I can't remember who's name, but it was my client's, I think stepfather is how it was, but it was a Tennessee estate. And the Tennessee estate just put it in their estate and kept the money. They did not pay.
You know, how you got them here? Hey,
No, my clients then, when the estate that was paid, when he passed away, it left the property to his wife and his children.
Yeah.
His wife and children then deeded it to his wife's children. And they've sued those people.
Yeah. What about the people down in Tennessee that got the money? They're not in this case.
I have no. nothing was, here's my understanding of the Tennessee probate. The lawyer said they never filed a claim in our state, so we didn't give them any money.
And I think the issue is that there, it wasn't a debt accrued prior to death, which would trigger, at least in Kentucky, the 6-month creditors period. 2 separate executors signed a written contract with Geoscience saying, we know that you need to perform services for these underground tanks. You all can do it. So Geoscience, they signed a contract with the first executor, then that property got distributed in that estate. And then while that second estate was open, that executor then, because they had a continuing obligation to service these tanks by law, so then they contracted again with Geoscience, that second executor, for the same services. And so Geoscience has never been paid.
It was the second person who received the state money, where the first or second executor they did a deal with. Is it somebody else that got the money?
Yeah, I don't know who's received what money or.
I thought somebody in Tennessee.
Receive any of the Tennessee estate because they were not an heir to that person, is my understanding, but I could be.
Okay, well, y'all get you a good PowerPoint. I'll try it. Hell. Appears to me that there's not a fact situation. Everybody might agree to the same thing, and it's just a law situation. You agree?
That's Brian's.
What facts? What facts that you might have that you think a jury might need to find? Are there any disputed facts? There aren't any disputed facts.
I do not believe so.
Okay. Okay.
If there are disputed facts, we'll let the clerks convene.
Okay, how much time do you need advance notice here when we can try the case? You talking about sometime in August? You want farther out than that?
That's fine with Mr. Pack. August is fine with him.
That's fine.
Are you going to the prosecutor's conference? Takes that out. I think that Friday the 15th, either Wednesday the 13th of August or Friday the 15th of August.
My client is out of town that week.
Okay.
He sent me asking for dates he was unavailable.
Never mind then. See, the next week is the prosecutor's conference, and I have a trial on Monday that week. Tuesday's district court day here, right? Then we got the next week is the Robles trial, which who knows how long that will last. That first full week in July, in August is when your client's out of town.
He's out 7/28 to 8/1, 8/4 to 8/8, and 8/11 to 8/15.
Well, what about July 30th? It's 2 weeks from now.
That's 7/28 to 8/1.
Oh, I didn't hear you say that.
He's out. No, from July 28 to 8/15, he's out.
To 8/15.
On the 19th on a Tuesday with the bench trial, it shouldn't matter. Oh, you'll be.
Yeah, that's what
Mr. Pack and I have attempted to negotiate settlement and we're nowhere close.
you need a heavy involved in it, so that's.
Yes.
On the 29th, did I have some kind of doctor's appointment that day? When did I do that doctor's?
The 8th. August.
Yeah. What about September the 12th?
I am available.
That should work, Judge.
Okay. Since we don't have to do jury instructions, why don't each one of you submit to me a kind of trial brief on what you think you're going to prove and what the issues are, okay?
And Judge, is it possible for witnesses to appear via Zoom, or would you like them here in person on that day?
Well, it doesn't bother me if they appear. If they've got exhibits, it's cumbersome sometimes. Will they have exhibits?
Don't know to what, I'm sure those contracts, so that's at least two. But beyond that, do not know.
Well, usually you don't, the contracts speak for themselves, you know, if you'll, if in your trial briefs, if you'll outline the portions of the contracts you believe are applicable, and then you might, we might agree upon, if there's not any real cross-examination of these people, y'all might stipulate as to introduction of those to cut down the number of witnesses, if there's nothing you need to ask them. Okay, if y'all will examine the witnesses to see if there's anything you need to ask them, if they would be having probative value on what's going on, we might be able to slow this thing down, okay? Okay. Ready to go.
Thank you, Judge.
Okay, thank you. What day? I don't know if I pushed that day in. What day was it? September 12th? Yeah, I got it pushed in. No, I didn't get it pushed in. I pushed in somewhere else. September 12th. Okay. Hellman versus Hellman.
Judge, that's Miss Anderson's case, and she re-noticed it again for next month.
Okay. Gerald's versus Scott. Okay. Hello, what do we have here?
Judge, this is my client's motion to modify custody and time sharing. He's asking for, at least in the temporary for sure, sole custody. We had filed emergency motion as well with supporting affidavits. The party's child, my client became concerned about drug
Are
use.
you represented by counsel?
I'm seeing Ron Hampton Monday morning.
No, a little late.
He couldn't get me until next week.
Yeah. Okay.
But just their very young child had a methamphetamine level of over 20,000. And then Miss Scott herself was positive for methamphetamine when she tested for the cabinet. So based upon the inherent risk to the child, we're asking to modify custody. And we're fine if we want to do a temporary order today and schedule it for a full hearing at a later date. If
Is the
Mr.
child here today?
No, he's only two. He's two.
Where is he today? You've got him?
Daycare. He goes to daycare.
You've got the child though. You know, what kind of access do you have to the child now?
I visit 1 hour a week,
And who did that?
CPS.
We're supposed to have hearings in juvenile court where they were supposed to ask to promote custody. It's been continued and continued and continued, so.
She's still a custodian, which is concerning to my client, because obviously there's nothing to prohibit her from picking up from the daycare or doing anything like that in the interim. So like I said, if I do believe that it is a necessary thing to protect the child right now. And
You're
like I
in
said,
drug court now.
Sorry.
Well, I think I'm going to just ask you to comply with the cabinet's order right now until you get a chance to get an attorney. I think that's fair. But I will add to that you shall not pick the child up in violation of the cabinet's order. In other words, she can't just go pick the child up and take off with it or anything. So I'll limit what you can do to what the cabinet has done. You draw an order to that effect till we
so
see.
is it okay if may I word it that her only contact with the child will be as authorized by the cabinet?
Is that what you're doing now?
I get a call every afternoon at 5:30 and I get to do an hour visit with him.
I think there's a safety plan with Lori Slaughter.
We done our case plan yesterday,
An hour, how often?
once a week.
Well, say that the visitation limited for now to what the cabinet does, and if they modify that somewhat, as far as allowing you to have another hour or whatever, but I don't want you to have the child away from the structured visitation thing, okay?
Sure.
And let's set a hearing, on this thing, a full hearing on, August the 14th, the afternoon, of August the 14th.
I'm set to be induced the first week of August.
Are you pregnant now?
Yes.
I just, it gives you 2 weeks to get over it. What do you want, Okay. Well, let's do it on September the 18th.
For 18.
Yeah, that way you can have a lawyer and it stays in place till then, okay?
Judge, we changed that motion to A to September 6th.
September 16th. I better put it off here.
What, I can't do September 16th. I don't think. We have, I'm showing on my calendar, I have another hearing
It
on
was just recently.
the 18th, the 18th
The
hearing.
18th bumped up to-
It got moved to the 16th.
Yeah.
So would that hearing that was scheduled for the 18th have been moved to the 16th as well? Okay. Okay.
I mean, you can be here on the 18th if you want to.
Don't know that it did do me, I mean, I love to visit
I won't
Monroe
be
County,
here.
don't get me
I won't
wrong.
be here.
So I haven't been to the coffee shop yet that I hear so much about. So,
Okay.
but it's in the afternoon. I'll do my best to be here.
Okay.
I'll just switch back schedule.
So you have an attorney, bring your witnesses that day, okay?
What time did you?
Let me just make sure I don't have any conflicts later that afternoon.
I'm showing the Capshaw case on as well. Do you have that? It was scheduled for 1 o'clock. And if you hire Ron, we work together a lot, so just tell him to get in touch with me.
2:30 ought to get it. Let's just put it at 2. And it might be 2. We'll give you an hour or so after that, okay?
Thank you, Judge.
Okay, thank you. Walden versus TJL Enterprises.
Notice of remand, sentencing.
They pulled it.
Yeah, need to put it on the docket.
Okay. And the next one is I don't have a next one
You have a different doc.
right here. Stinson versus Graves.
Miss Coleman is one of them. She'd stay out.
Malum versus McKenzie.
They're both the same.
Both the same case. Okay. I guess somebody needs to step out and tell Miss.
Well, Judge, if you don't mind, there's a couple more minutes. Miss Coleman and I are trying to come to an agreement. So we don't.
Well, I don't mind at all. I'll reassure you, if you'll come to an agreement. Y'all, let's go off the record.